Yes.
My lord, I'd like to mention item number 25 and 26. It's a hearing matter, my lord. Here I'm appearing for the appellant in item number 26, my lord. So, my lord, I was under the impression that I had already filed my wakalatnama, but since it is not reflected, my name is not reflected, I checked the records and it seems, my lord, that I have not yet filed, my lord, wakalatnama.
In 26?
In 26, my lord. And in 25 also I'm appearing, my lord. But here, otherwise also Mr. Picha, who is appearing for the appellant in item 25, he has some difficulties, my lord. He has had head and stroke, and because of that he's undergoing treatment. So I've already.
So this is arising out of the same judgment?
Same. It's against the sentence, and another, both are against the sentence only, my lord. One is for enhancement.
Okay.
Item 25.
So for the other side, who is for the other side? You are
My lordship, I would like to mention item number 24.
No, I have spoken.
No.
I have
24 is also connected?
No,
No, sir.
Wait then.
Item 25, my lord, I have spoken with my lord Bintar Picham.
Okay.
He is in this post, my lord,
Okay.
because of difficulty.
Okay, Mr. Soki. Now, council. You are only in 26.
In 26, I am for the appellant, and 25, I will be
26, who are these other? Okay, they are no longer.
They are no longer there.
Okay.
Mr. Ratan, since after his appointment.
Item 26, submit. That although you have filed wakalatnama, not yet?
Not yet, I'll be filing.
Okay. Submitted. He has newly been engaged in this appeal to appear on behalf of the appellant. However, he is yet to file wakalatnama. Though whatever the earlier, they are no longer means.
No, they are no longer appearing. Because earlier Mr. Ratan was appearing, he was engaged, but since his appointment as the AAG.
Yet to file wakalatnama, for which he prays for how much time?
Well, can it be after 4 to 6 weeks? After 6 weeks, my lord.
6 weeks?
Yes, ma'am.
Why
Because
6 weeks?
Mr. Picha, he suffered from a stroke, my lord.
Okay.
He's undergone physiotherapy. He is having motor and speech difficulty.
Just a minute. The accused, how many accused are there? For the same accused or different accused?
For the same.
For same accused?
Yes, ma'am.
For the same accused, then you can appear.
No, in item 25, I'm appearing. Item 25, I will be appearing for the private respondent. And in item 26, I'm appearing for the appellant.
Okay. Then he is appellant in item 26. And then in 25, respondent. Prays for 4 weeks. He also prays for some time. He also submits appellant in item 25. Mr. B. Picha has some personal difficulties, due to which he requested him to seek adjournment. In view of the above, and I prayed for at least this matter after 6 weeks. Okay.
All right.
My lordship, I would like to.
Sorry, my lord. There's an interim order as well, item 26.
In which?
26.
What interim order?
That's the sentencing was stayed.
Sentence was stayed.
Yes.
Okay. The stay, the order passed earlier shall continue till the next date of this. Okay.
All right.
My lordship, I would like to mention item number 24.
24.
I represent 24. I represent on behalf of the land council, Mr. D. Bose. My senior is out of station.
You are for the appellant.
The petition, yes.
Have you informed the other side?
Yes, I have taken the question from the other side.
You are Mr.
Martha sir.
Appearing on behalf of Mr.
D. Bose.
D. Bose, Land Council for the appellant, with the consent of the Land Council for the opposite party, prays for
Adjournment.
adjournment for
3 weeks.
For 3 weeks. So the prayer is allowed. This matter. Okay.
Lordship, I beg to mention item number 5, Your Lordship. Leading counsel is out of the station, Your Lordship.
Yes. It's a criminal revision petition.
Yes, Your Lordship.
So I'll inform the other side. You are for?
Yes, I am for Lordship, I have been petitioner in item number 70. It's connected matter. It's connected matter.
Which one? Item
70. I am petitioner.
17
Yes,
is connected with the present one.
yes.
No, connected with this item 5.
Yes.
NIA case
17.
17.
Five.
How it is connected with item 5? 17 is?
Sorry, sir.
Okay.
Miscalculated.
Yes, in item 5, who is for the other side?
Your Lordship, I have taken,
You are for the petitioner.
yes, Your Lordship.
What remains there? What remains there in this item 5? What is this matter about?
Criminal revision petition, Your Lordship.
Okay, revision against.
Again,
Order passed in NIA case.
yes, Your Lordship. Order passed by Honorable Court, Honorable High Court in criminal revision petition, Your Lordship.
High Court did not pass any order. Order passed by judicial
JMFC,
magistrate
Your
first class.
Lordship. Yes, JMFC, Your Lordship.
Okay. Okay. Whether you paid amount,
No date,
paid the amount,
no date, Your Lordship.
not yet. I think you need to obtain proper instruction. I think they have already paid. In that case, what remains? That is what I am asking. You have informed the other side.
Yes, Your Lordship.
You are Mr.
P. Wangpan, Your Lordship.
Lana Council appearing on behalf of Ms. J. Jongluju, Lana Council. No. So the council is out of station.
Yes, Lordship.
When you make a mention, come prepare with. Okay, when you make a mention, come prepare with at least basic question we'll be asking. And in, if required, we'll also go for hearing also. Okay, come prepare. Whenever you make mention, don't just mention blindly. Judge will be requiring some information from you, even to adjourn the matter also. Here probably they have already paid. Interest part remains. I thought of disposing of this matter. Anyway, Mr. So-and-so, submits that the leading counsel, Ms. J. Jongluji, is out of station. Therefore, prays for adjournment of the matter for how much?
2 weeks.
For 2 weeks. He has also obtained consent from the other side of the from the council for the other side. In view of the above, let this matter be listed after 2 weeks. Okay.
That's okay.
Yes.
My lord, I beg to mention item number 15.
Item 15.
Yes, Your Honor. Leading
This is
counsel,
in order. Let us see what is there. Okay. This is in order. Nothing will happen. We'll grant adjournment, but wait for some time. Okay.
item number 1.
Yes.
May I please, my lord?
Hmm.
My lord, I am challenging the order dated 10/6/2021, my lord,
Hmm.
passed by the learned Civil Judge Senior Division Pangin,
Yes.
wherein the delay of 1083 days in filing appeal has been condoned, man.
Yes. What
Solely
is
on
your
the
problem?
merit of the main case, man.
Where it has been observed.
my lord,
on merit? Which portion you are agreed by? Which portion of the order?
my lord, kindly, come to page 75, my lord. Annexure 11.
Yes. Yes. 75 is, how 75? Where is the,
My lord, 75.
you
my
are
lord.
agreed by which one? Page 75,
Yes, my lord.
Where it is?
From sixth line, my lord. It also saw that the applicant had lodged the complaint with EAC Pangin
Hmm.
on 7/10/2021 against the impugned Kabang decision, which is respondent disputed. My lord.
come
My
to the
lord,
conclusion, come to the conclusion
My lord,
for which it was
my lord, kindly turn the page number 76, my lord.
70?
6, my lord.
Yes.
Perusal of the impugned decision also revealed that the village authorities proceed ex parte against the application in terms of some rules prescribed by ABK, which does not per se appear to have the sanction of law, man. Next paragraph, my lord. In the light of foregoing, the court is inclined to condone the delay in filing the appeal, as it is evident that the applicant was not deliberately negligent in pursuing her right.
See,
The applicant illiteracy, my lord, combined with her belief that her complaint was still pending before the EAC, my lord, constitute sufficient cause for the delay. Furthermore, my lord, the village authority raised legitimate concern about the procedural correctness of the impugned Kabang decision.
but basically it was condoned only because of this reason that
My lord, while dealing with the condoned application, my lord, the court ought not to have deal with the merit of the case, my lord.
but the ground for condonation is applicant was not deliberately negligent in pursuing her right. The applicant's illiteracy combined with her belief that her complaint was an EAC constitutes sufficient cause. This is the ground for condonation of delay.
My lord, next paragraph, kindly come to next. Furthermore, the action of EAC and village authority raised legitimate concern about the procedural correctness of the impugned Kabang, my lord.
There is no decision on that, no appreciation.
My lord, this is the continuation of the disorder, man. Same line, man.
But the basic ground for condonation of the delay is the above one. Is only raised question.
My lord, while dealing with the condonation delay, my lord, the learned court below has entered into the merit of the case. my lord.
Where they have entered into merit of the case? Where the merit of the case has been discussed?
My lord, from page number 76, my lord, para 2, my lord. It started from here, my lord. Perusal of the impugned decision reveals that the village authority ex parte against the applicant in terms of some rules prescribed by ABK, my lord.
This is
It should,
procedural part.
it should
not
not,
on merit.
it ought not to, it should not have to
This,
discuss.
this is also the referred to the procedural part only, merit of the case. See, the civil revision on a 115 is a limited scope. especially the jurisdictional error, isn't it?
My lord, otherwise also, my lord,
So they have appeared.
no, my lord.
This was passed when this order was passed.
My lord,
What happened thereafter?
order has been passed on 10/6/2025.
Yes, that is why I'm saying. I'm asking what happened thereafter in the court? The
Therefore, my lord, there is still, the applicant is still not filed their main appeal, my lord. It is still pending as it is, my lord.
how it is possible? It's not possible.
I don't know, my lord. Like, however, my lord, they did not file, my lord. I have even applied for the CTC, my lord. But it's said that they still not filed the appeal, my lord.
Okay. Hard, Mr.
Mdoji, my lord.
Mdoji,
Yes, my lord.
Planning Council for the petitioner. By filing this application under Article 227 of the Constitution of India, read with Section 115 of the Code of Civil Procedure, the petitioner challenged legality and validity of the order dated 10/6/2025, passed by the Managed Civil Judge Junior Division,
Junior Division.
Panging, Siang District. In Miss Case number 08/2024, by which the delay of
1083.
1,083 days in filing the connected appeal has been condoned. Stop. According to the petitioner, the delay was condoned. While condoning the delay, the merit of the case has been considered, which according to the petitioner is in violation of settled proposition of law. Record need
Yes, my lord.
call for the record. Call for the scanned copy of the record. Huh? We'll call for the scanned copy of
Yes, scan copy, my lord.
issue notice. The petitioner shall take steps upon the respondent by a register post with edit as well as by usual process within a week from today. Sir, list this matter after 4 weeks.
My lord, in the meantime, my lord, my interim may be.
What is that? You said that they have not yet filed.
The impugn dated, my lord, 10/06/2025.
What is it is going, how it is going to affect you?
They may be filed, in the meantime, they
You
may
file
be filed.
separate? You file separate? What is the decision? What is the prayer?
Operation of the impugn order dated 10
See, the impugn order was 1,080, how many days?
1083.
It was not yet affected you. How it is going to affect you?
In the meantime, my lord, they may be filed, my lord.
we need to examine.
In that case, my lord, endeavor will be made to consider my.
Now, they will only be allowed to file appeal.
Yes, my lord.
What this means, isn't it?
Yes.
By allowing this. So if we stay means they will not be allowed to file.
Yes, my lord. At least, my lord, till the returnable date, my lord.
We do not know. By now, they must have filed. It was allowed some 3 months back.
Yes, my lord.
Let them appear. Okay.
In that case, my lord, endeavor will be made to consider prayer on next day, my lord.
Okay, the interim prayer shall be considered on receipt of the record.
Yes.
Okay.
All right.
Item number 2,
Mayor, Lordship,
Yes.
I have filed this for quashing and setting aside of a criminal case regarding to Itanagar BS case number in 01/21 and regarding about session case number 05/21 for quashing. Lordship. Moreover, my lordship, if we go through the records.
What is the stage of the trial?
It is in the evidence stage, my lordship.
Evidence not yet complete.
No, my lordship. It has not been completed and still yet there are evidences has to be taken. And victim has to be examined. And moreover, victim has to be examined and together there is a this one correlatively if we speak, there is other evidences are also to be recorded.
See, this offense appears to be very serious.
Yes, yeah.
And in that case, how it is possible?
My lordship, this can be considered only on the ground of settlement that is.
How it can be settled?
My lordship, since they are
When the offense
brother-in-law and
affects the
son-in-law.
society at large,
My lordship,
how such case can be settled?
they are socially, they are obligated, my lordship. One is a son-in-law, the other is a brother-in-law. The incident took place only because of some misunderstanding on it.
See, the such cases taking place in between the father and son also,
Yes,
brother and sister, brother also. But then when it affects the society at large, it's very difficult.
yes, my lordship, but this is a case of an individual personal,
In that
Issues.
way, all are in.
my lordship.
That-
No, my lordship, I mean to say,
Then the murder. is individual.
no, when the mother or some kind of a rape cases or if it is in societal effect, it will cause a different problem. But it is not in that,
The
this,
allegation itself is very
on my
grievous.
case, my lordship.
I think it will be a little difficult.
And the ruling, if I go through the ruling also, it says,
Yes, what says? What it says?
my lordship, please. May I take? My lordship, please. May I please, my lordship?
Yes.
Coming to the cases of Jian Singh, Narinder Singh, and after that, what the Honorable High Supreme Court has placed, and its Honorable Court also has.
307, 326 also.
Yes.
And
my
despite of
lordship.
there is a clear evidence
Yes,
against the
30,
accused.
no, my lordship, there is no.
There is a clear evidence against the accused. The eyewitnesses clearly stated, deposed before the court.
No, my lordship, that is not correct, no?
Okay, let us see, you have, you are yourself. has-
And
yeah,
my lordship,
Next. Come to the
I,
evidence.
I would give to the honorable court the question judgment that has been passed by this honorable court. In cases of Hibu Raju versus state of AP in criminal petition number so and so 11
See, all
AP
every-
2019.
has some different facts and circumstances.
Yes, my lordship.
But
No,
there is a
my
case where there is a clear evidence against the accused.
My lordship, please, may pursue the.
Hmm.
And I have earmarked also. My lordship, please.
Which paragraph?
It's in para. Let's come to this one, 3. Exactly, I want to 3. The present petition has been filed by the invoking the provisions of section 482 of the CRPC for setting aside and quashing the sessions case number so and so in 0 PS case number
333.
so and so. Section 333.
Let's see.
It was interpreted.
What is section 333?
Section 333, it causes of a grievous injury which causes to a human death.
What is the punishment?
Punishment is more than 10 years. And my lordship, please, the honorable court, what they have justified. We can come to that also. Come to the FIR, after that FIR accordingly, the opposite so and so, referring to the petition itself. The learned counsel for the petition submits that both the accused and the victim has already settled the matter outside the court.
That is different.
This is the fact.
326.
And another,
Clear evidence.
my lordship,
You cannot
please.
compare with this.
My lordship, please, I'll come to our question, my lordship, please. And in the GLP 2019, one of the matter, it was concerning about the shooting. 2019, page number 110. There is a, whenever there is a settlement has been arrived within the parties, then the honorable court is to decide.
See, that is what I'm saying. It depends on the case.
My lordship. This is a shooting
This is
case.
333,
Again-
altogether different.
Yes, my lordship. If we come
See,
to that,
There are so many
my
provisions,
lordship, if we
so
come
many
to the
IPCs.
Previous report, it is concerning about 302 and 307 and 308, it's attracting, my lordship. And charge was framed. And my lordship, please come to one of the cases which was decided by this honorable court in 2000 regarding about
Where is the relevant?
yes, I'll be giving. Okay. My lordship, I'll come to the paragraph 5.
Where is the? No,
This is
this,
concerning about the burning of a vehicle.
which one you are, huh? Which one?
My lordship, 2017, it is regarding about state of Arunachal Pradesh versus Viri Tabing and others. This is concerning about
See, this is, see, 140, this is nothing, 149, 435.
Yes, my lordship, each and every crime is connected, my lordship. The offense they have committed, whatever these may be, punishment is same. My lordship.
The fact and circumstances of this case is altogether different.
My lordship, please come to para 5. In para 5, it has been clearly mentioned by this honorable court, the question judge has observed, and after observing the fact and the case has already settled, when the party, they have settled their own dispute within themselves, then it is not a necessity, or it will be a futile exercise, my lordship. The principle itself.
These offences are not so serious, clearly observed.
No, my lordship, it is.
See the next
no,
paragraph?
no, my
Offences are
lordship,
not so serious.
yes, my lordship. It is observed that it is a very serious crime, maybe, my lordship, when there is a settlement.
No, the court has
And,
observed that the offences are not so serious.
And my lordship, in the Lakshmi Narayan case also, it has been observed.
So,
it
so the
has been explained.
Lakshmi Narayan case, so what it says? The offense are not, see, Mr. Vincent, the Lana PP them himself submits that the offense are not so serious in nature and the same does not fall with the category of cases which cannot be lawfully compounded. Different, altogether different, you see, whatever you have submitted. Anyway, what we'll do, yes, Lana PP,
Yes, with Lordship already pointed out that this is a heinous offense against the society. Lordship.
yeah, that is
Not
what I'm
against the
saying.
individual.
Yes, also.
And, yes, Lordship.
But then,
Lordship, in the instance, TCR may be called for this contempt.
okay, so we do not know what is the stage, and it appears that so many evidences has already been recorded. Witnesses has been examined, and then there is a prima facie case, it appears. Clearly
My
the
lordship,
eyewitnesses is
My
stated.
lordship, eyewitnesses are there, maybe whatever it is, maybe either examination is still yet to be done.
How can we discard that?
No, my lordship,
And in
I'm
the
not
serious
telling that
case like
it
this?
has to be discarded.
How?
No, I'm not telling that it
In
has
petty
to be
cases.
discarded. But it is not against the societal now, my lordship.
So what type,
Is
in a criminal case, what type of cases are against the society? Just tell me.
that is murder, rape, and POCSOs are there now to be included.
This is attempt to murder,
This is an attempt to murder, but
307.
it can be
And
considered.
then ultimately it came to 326 also. Grievous
Yes.
injury.
Yes, my lordship.
Eyewitnesses have already stated.
My lordship, it is a offense done to an individual, my lordship.
That was the.
The Supreme Court says, my lordship.
Mr.
T. Johnny.
Hmm?
T. Johnny.
P,
Johnny.
your name is there, no?
Yes, my name should be there, but it has not been reflected, my lordship.
Not in counsel for the petitioner. Sarah. This application has been on this application under section 482 of CRPC 1973. What is this?
528, my lordship, BNSS.
Okay, this application file under section 528 of the NSS 2023 has been filed jointly by the accused and who is how many accused persons are there?
Only one accused is there. And he is the son-in-law.
3%. The one is the victim.
Yes,
The
no,
accused,
no.
The
My lordship.
the informant, the victim, and which one is accused?
My lordship, petitioner number 3 is the case.
And the accused
One is Lordship.
seeking quashing of the. Where is the session case of the session case number 05
0521,
2021
22.
arising out of Itana case number 01 2021 under section 307/326 IPC. Stop. Also, the scanned copy of the trial court record. Since Mr. Lloyd, non-PP, appeared and accept notice on behalf of the state, the formal notice stands way. Stop. After? When? After 2 weeks. Okay.
My lordship,
Case of which case?
till,
Which court?
it's in session court.
Yeah.
Until then, my lordship interim may be granted. My lordship,
Yes.
interim may be granted, my lordship.
No, there is a clear case. I have seen it. Only it has to be confirmed from the record.
My
How do we
lordship,
stay- how do we- how do we, see? We do not know the stage also. 313 or the.
no, my lordship, I'm telling you, it's in the period of evidence now. And it has not been recorded yet now.
You have annexed so many evidences.
My lordship,
Appears that the
no,
evidence.
no,
has
my
already
lordship,
completed.
I have given the deposition statement that is made before the 164 statement that has been made before the honorable court.
At the last stage, at the stage of,
And my lordship, if we go through the records, if we come through,
it is not going to affect you, even if the further evidence takes. If you see succeed a case, it automatically will go.
my lordship, even
If
though
you
it
say-
will be kept in
No,
abeyance for some week,
No, stay.
my lordship.
Okay, next.
Item number 3,
Yes.
My lord, this is a joint application, madam.
Hmm?
This is joint application, madam, for quashing of the FIR, madam,
Okay.
dated 19/11/2024.
What is the offense involved? Let us see the complaint.
My lord, 305, madam.
Hmm?
305, madam.
Okay, what is?
Theft in dwelling house. My lord, page number 19, madam, FIR.
What is 305?
Theft in dwelling house, madam.
Okay. This
May I
one,
read, ma'am?
Okay. Hmm. Okay, we have stolen.
My lord,
This
petitioner,
this is a joint petition.
yes, madam.
Okay, after investigation, the police has filed already charged it.
Yes. No, my lord, it is at the appearance, stage of appearance, madam.
Notice was issued.
Yes, madam.
Where have you mentioned the GR case registered before? Cognizance must have been taken. Where have you mentioned the GR case? Which court?
My lord, CGM, madam. UPM.
Where have you mentioned?
My lord, page number 6, madam, paragraph 7, madam.
What is your prayer?
My lord, quashing of the FIR and connected charge sheet, madam.
Corrected charge sheet?
Connected charge sheet, madam. My lord, this is
Charge not yet framed.
not yet framed, madam.
Okay. Cognizance taken.
Cognizance has been taken, madam.
Okay. Joint petition. Where is the agreement?
My lord, page number 32, madam. This is arose, my lord, due to the miscommunication between the parties, madam. Petitioner number 2 is the employee of the petitioner number 1, madam.
Whether you have received back the vehicle,
Yes, my lord.
the owner. He says that he fled away. by stealing the vehicle, whether the vehicle was received back.
Yes, my lord. The vehicle has been already recovered, my lord. And my lord, page number 31 is Jimma, my lord.
31.
Yes, my lord.
Yes, Mr. Oh, Mr. Whether record need to be called for or it can be disposed of.
Lordship, because it's already, Lordship, charge is submitted and the only of someone state, Lordship.
Yes.
Altogether, it can be disposed of, Lordship. The only my concern is regarding the signature, Lordship.
Which
The signature
signature?
of the accused, Lordship, in the page 19 and 34 is the different
19 and
34.
34.
Yes,
Which
Lordship.
signature?
Yes,
Whose signature?
complainant, Lordship.
Complainant.
Yes, Lordship. 19 is complainant signature is different as compared to the signature.
Nur Amin.
Yes, Lordship, page 34. Otherwise, other, I have no problem, Lordship. Only the signature part.
Well,
Lordship.
signature in page 34, my lord. The signature here
Nur
he
Amin is a name,
wrote his name.
and then here Nur Amin
The name after,
signature
above name, he put his signature as different. Lordship.
looks like
Name
different.
is already, yes, name is already there, Lordship. Otherwise, Lordship, there's a petty case, Lordship. I have no problem quashing, Lordship.
Where are they? This is which PS?
Itanagar PS, man.
Itanagar.
Yes.
Whether Nur Amin is in the station?
Yes. my lord. He is at the Ganga market, my lord. He is running vegetable market.
What do you say? You want to confirm?
Lordship, if his Lordship,
My lord, this is same
Where-
person, my lord.
Where is that?
it's up to him, Lordship. If he satisfy the court, that I have no problem, Lordship.
No, in the Wakalatnama and this agreement, it's same, Nur Amin.
10 is fine, Lordship. Then.
Hmm?
If Bakul number
If
is same, Lordship,
Wakalatnama
10
is
is
same.
fine, Lordship.
But then information can be given by anyone.
Maybe he forgot
But it's different. Huh?
his signature.
Charge sheet also filed under 305.
Yes, man.
We'll dispose of, no point.
Lots of them.
Even if we
It's
call
very
record
pity,
also,
Lordship.
because of petty cases and he has received the vehicle. Jima, page number you said?
Page number 17, I think. Oh,
Okay.
no, my lord.
Nur Amin.
31, man.
No, here again, Nur Amin signature is again different. This and the complaint is different. This and complaint is same, and the Wakalatnama and the agreement, which is in favor of the accused, is similar. And
In
this-
my lord, Wakalatnama and agreement, man. There, he
See-
wrote his full
see
name, my lord.
how he can change all the time. This Jimma and the complaint is in favor of the complainant or informant, and the Wakalatnama is in favor of the accused. So that two are same and these two are same. It's different.
My lord, in Wakalatnama and agreement, my lord, he wrote,
That is in your favor. That is in the favor of the accused. That is where they are same. And Jimma and then the FIR is signature is different.
yes.
They are same again. There is something we may go wrong. See, we don't, let us not take risk. So we'll call the, this one,
PCR, Lordship.
this
It's-
year, the informant
Yeah.
before the court to come, come with his, Aadhaar or ID, whatever may be,
Yes, ma'am.
he should be present with his signature in the
Yes.
Aadhaar.
Yes.
Okay? On that, or TCR may not be required because
Lordship, it's only a
okay.
summon state, Lordship, yes.
Confirmation of identity.
Yes,
You check the identity and then if you satisfy, we'll pass order. Because only in two document, which is in favor of the informant, the signature are same. And in two documents, that is agreement and wakalatnama, is different.
Lordship is calling them in person, then Lordship, I have no problem, Lordship. In the also.
Okay. Then in that case, we'll call for a PCR also.
Yes.
Scan copy. Okay,
Yes, sir.
so that the trial court should also know it has been taken up. Mr.
M. Doji, my lord.
Planning Council for the practitioner. Para. This application under section 5 to 8 of the BNSS 2023 has been filed jointly by the, which one is accused, which one is informant?
Pitch number 2 is accused, my lord.
The informant and the accused in accused setting aside and quashing of the GR case. See, in the beginning itself, you should have mentioned GR case in a course title. It's very difficult to find out. GR case number 1198, 2024, arising out of Itanagar PS case number 219. So, what is this?
My lord, deeply apologize.
It should be corrected. What is this?
It should be 2024.
2024. Huh? Correct it and
Yes,
keep
yes.
it like that. Otherwise, it will be difficult to pass order, final order under section 305B of the BNS. Pending before the Chief Judicial Magistrate of Mpare District, UPI. Stop. Huh? Call for the scanned copy of the trial court record, which we notice. Since Ms. L. Hage, Planet Additional P2, is present and accept notice on behalf of the state respondent, the formal notice stands waived. Huh? Stop list this matter next week
Lordship,
or Monday
Lordship, yes, Lordship, Monday to can it, Monday.
or this week also if you.
Have an interim prayer, my lord. Otherwise, not done in next week.
Next week, yes. So it's only scan copy only. Can we fix it on 19 or 10?
Lordship, any day.
No. Okay, 15. Okay, stop it. Sarah. In the meantime, the proceeding in year case number 1198 of 2024 pending before the Judicial Magistrate UPR shall stand stay. Okay.
Yes, lord.
All right.
All right.
Item number 4.
Yes.
May I please, Lordship?
Yes.
Lordship, this is a quashing petition under 482 of CRPC. Lordship, for the last date, this on in our petition not mention the GR number of the case. So accordingly, this honorable court has directed the petitioner to file an additional affidavit, and accordingly, today I have filed an additional affidavit showing the GR number.
Okay.
Lordship.
It is on record.
Yes, Lordship. Page number 42, page number 49. Additional affidavit. Today only I have filed, Lordship.
Okay. What is the
Yes, GR number is Lordship
No, just a minute. What is the offense involved here?
304 A. Lordship, that
Accident
caused,
case.
yes, Lordship, accident case,
Okay,
motor accident.
or accident.
Yes,
Is it
Lordship,
injury or death?
death, Lordship, death,
Death case.
death, yes. And the victim's father and the accused person, they have already settled the matter outside the court, and some amount of compensation has already been paid to the victim. It's a all pending case of 2012, Lordship.
But, see, nowhere in the FIR also mentioned that the person died,
Yes, Lordship,
even in the charge sheet also.
Lordship. Only in the heading of the charge sheet, 304A has been inserted. On the last occasion, Lordship,
The charge sheet also, charge sheet was filed long after the accident. Then charge sheet also only says 279, 338, and 427 only.
yes,
Nowhere mentioned the date of the
but Lordship, page number 19,
19.
yes, 19.
What is that?
19, in page number 19 of the chart sheet, they have mentioned 304A. In the top,
Who has stated that the person expired out of this accident? When he expired, not on the spot.
yes, later on, when he was evacuated to
After how many days?
Lordship, maybe after Lordship around 17, 18 days.
So maybe, but probably before filing of this charge sheet only.
Yes, Lordship.
But charge sheet mention, does not mention.
Lordship, in chart sheet, there is some defect in the chart sheet. Of course, it can be seen from the record. But in the top of the chart sheet, sections is 379, 338, 427, and 304.
Nowhere if the person has stated that subsequently he expired and but was inserted,
It-
how he can?
Lordship,
That-
FIR was lodged on 3rd November 2012, Lordship, and search it filed on the same date, Lordship, at phase number 23, Lordship. Oh, no, sorry,
No, it's not possible then.
sorry, Lordship. A mistake.
2013 only.
Yes,
Charge sheet filed, see, long after,
yes,
2013,
yes,
February. So
yes, Lordship. Sixth
after
February.
3 months,
Yes,
after
yes.
3 months.
Yes.
By then, if the person died, well, he should have, actually, he is supposed to know that. But in charge sheet, nowhere mentioned, nowhere, whether have you annex statement, anywhere in the statement, this date has been mentioned.
No, it's not been mentioned.
So what is, where is the case pending? Have you annexed the order of the magistrate?
Yes, Lordship.
So where,
In my additional affidavit,
what is the status of the case?
Lordship, status of the case is just for the appearance of the accused person.
Appearance
Yes,
in the summon, whether 304 has been mentioned.
that is not been mentioned. Your Lordship, page number 48.
See, in the court record also, it's only 279, 338, and 427 only. No 304. Court records, order dated 24/4/2023. 22/8. No record.
Lordship, otherwise in that case, Lordship, LCR.
But he expired.
Yes,
Okay.
expired, and the accused person has,
The expired due to the injury he sustained. Okay.
and the accused person has compensated him a bit.
Compensated.
Yes, of about rupees 5 lakhs. And now they have already settled outside the court, and they have the father of the accused person, the father of the victim, has came as a petitioner number.
Is it petition number?
2.
Then, see, why the victim's name is also what is the victim name who expired according to you? Name of the victim? No, this, then who is this petitioner number 3? You say victim. Or two victim. So,
They
like-
came in a motorcycle.
came in a
The
motorcycle.
rider of the motorcycle died, but the pylon driver.
Okay, then let us see the agreement. Who entered in the agreement?
Page number 34, annexure number 3.
Yes. In the first,
The settlement agreement made on.
what is this? In continuation of page 34?
Yes.
Why it is said that it is in continuation of their earlier agreement also? Where is that earlier agreement?
That also. But that earlier agreement, they had some compensated from these victims. There it is.
Bhardwaj. Just, yes, just a minute, let us confirm. What is the name of the accused?
Kiranjan Bhardwaj.
Bhardwaj, okay. Kiranjan Bhardwaj is, okay, it was decided in Kebang. Kiranjan Bhardwaj is accused, and then Panyang. And your Panyang is the
Father of the victim. And
victim is the person who expired.
yes. And second fellow is
Just a minute, where do we find that he is the father of the victim who expired?
in the FIR also.
No, in the agreement. Where have you mentioned?
For 2012, it's almost 11 years before. Motorcycle, the motorcycle.
No, the identity. Let us confirm the identity. Can you find where he has stated that he is the father of the person who expired?
Here it's paragraph.
Which paragraph? Tara?
That's on 211. It's almost 11 years ago. The motor medical accident that occurred on the way from passenger to reach, where both the parties were moving in same direction. Whereas the first part was elite of Russian, thus driving force death of Payan, the son of second part,
Okay, son of second party.
and was injury to the third part. Third party is the survivor. Accordingly, Ruxin P. Protection.
Mhm.
As per settlement agreement made on 30th of January 2030, that groups as per Bijum Javan decision given on dated 2nd December 2012. The present case has already settled between the parties under the chairmanship of Kamat Jonna. As per terms of the state settlement, the first party that is the case as given to his 5 lakh only. As a full compensation to the deceased and it includes medical expense and legal expense.
And then whether the victim family has also filed MSCT case?
No.
There was no insurance. No insurance. Okay. Yes, anything?
No, sir.
Just
This is accident case, Lordship.
he has adequately been compensated.
Yes, Lordship.
Okay. Hard, Mr. P. Daba, land counsel for the petition. Also hard, Mr. Law. than a PP for the state. Stop. Tara. This is a joint application filed under section 482 of the Code of Criminal Procedure 1973 by the accused, informant, and the victim in Corruption PS case number 17/2012 under section 279, 338, 427, 304A of IPC. Stop. Huh? And then question. Okay, praying for passing on setting aside. The GR case. Where have you mentioned?
Lordship, additional activity, page number 40, there are two. Page number 43, there are two. That the petitioner begs to state that in compliance with this.
Okay, GR case number 17/2012. Arising out of the above Corruption PS case number 17/12. The petitioner number 1 is this. The petitioner number 2 is the father of the complaint, father of the deceased. And the petitioner number 3 is another victim in the above Corruption PS case number 17/2012. Stop. Huh? Well, the prejudice in brief is that on 3/11/2012, a written FIR was lodged by the petitioner number 2 against the petitioner number 1 for commission of offense under section 279, 338, 427 IPC. Okay. Accordingly, the Corruption PS case number 17/2012 was registered under the above sections of IPC. Stop. Right? The case was investigated into, after completion of the investigation, the case was submitted into charge sheet. As in the meantime, the victim expired. Accordingly, the 304A IPC was added in the, while filing the charge sheet against the accused. Stop. The case was taken cognizance of. Now it is pending before the Chief Judicial Magistrate. Right. Pasigar. Stop. Para. We submitted that in the meantime. Actually, it was settled when? It is submitted that the learning council for the petition submission that the matter was amicably resolved between submits that since it was a accident case, the matter was amicably settled between the parties way back on
The date is
30 January 2013.
No, Lordship, 22 December 2012, Lordship.
Okay, the next is 30 January.
Lordship, yes.
That was also 2013.
Oh, yeah, it was on 2000.
First, when it was settled, you said? Okay, settled on 22nd December 2012. That record is not with us. 22nd December 2012. And subsequently, on what is this date? 30 January 2013.
Yes, Lordship. We made a settlement year after year. They actually thought that the case is what it is.
Okay.
Later on to the year 2024, and the matter was
No, the agreement made on 30 January 2013.
two cities of Debawas.
Finally, it was reduced into writing on which date? 15, 16, 20. No, there was 3 sittings, 30 January 2013, 22 December 2012, and 14 June 2022. No, 22. So finally, 15 June 2023. This is in continuation with the settlement of agreement made on 30. As per,
The matter was already settled.
see page 34. Kindly see page 34. There are 3 dated. Are these 3 dates are date on which the settlement was made subsequent? There is 15 June and 16 June also signed so many things. 14 June also. Type on 14 June, sign, one sign on 15 June, one on 16 June. No, why then 16 June again?
When the matter was came before trial, they thought that all the parties before settled, matter has been already settled before. And we get this settled in that case, but they have no knowledge that is the trial of it. Later on, when the question was summoned by the Nanak trial, they made this settlement for coming for this settlement.
June 20. No, it's again in writing. You see, first para is 22. So many confusion. Have you seen? typographical mistake. There are so many mistakes it appears. Okay. The land council for the petitioner submits that immediately after the incident, the matter was settled on 22 December 2012. Before the PEBA. And thereafter, when the summon was issued, to the accused, again, it was settled. Again, it was. This was also in written form. No, it is not available with you. Settled on January 2023. And finally, it was released into deed of settlement on 14 June or 15. It's typed 14, signed 15. Which one is correct? Reduced in the writing of 14 June 2023. But signed on 16 also. You have seen 16 also. First page, 34. Signature one is signed on, signed on 16.
Yes, Lord.
Reduced in the writing of 14/6/2023, which was signed on 15/6/2023 and 16/6/2023. Whereby the whereby the victim was adequately compensated by paying rupees 5 lakhs as a full and final compensation amount to the deceased, to the victim's family, which includes medical expenses and funeral expenses of the deceased staff. The informant has also clearly expressly stated the settlement deed that he has, since he has received the full and final compensation, he has no further grievance against the accused, and he does not wish to pursue with the matter any further. Stop. Public prosecution fairly summarizes that, since summarizes that in view of the settlement deed entered between the parties, settling the resolving the disputes, he has no objection if the prayer of the petitioner is allowed. Petitioners is allowed. Okay, I'll conclude. Okay. Rest in it. Okay.
Item number 6 and 7.
Yes.
Please, your lordship.
Yes.
Lordship, the counsel, the leading counsel of the petitioner, your honor, he is still on the way, lordship. His vehicle breakdown midway, your lordship.
So notice was not issued.
Totally, no.
Yes, Your Honor. Lordship,
They want it taken up tomorrow, man.
Want to take up tomorrow? Okay. Earlier also it appears
Yes, yes.
a second time.
Yes.
Okay. As prayed for, no objection.
No, I have no.
Tomorrow.
objection.
Okay. As prayed for by Miss
Puja Pradhan
Lani Council appearing on behalf of Mr.
and Sharma.
N. Sharma, Lani Council for the appellant. Let this matter be listed tomorrow on
Right.
date. Okay. Mr. Bikita, you are already appearing.
Yes,
Lani Council for the
That was
respondent
clear.
is also present. Okay.
problem.
Item number 8.
Tomorrow, just a minute, just tomorrow list already prepared. Day after tomorrow then, in that case. Tomorrow list already prepared.
Your Lordship, I have to communicate with the senior. Your Lordship. He is in the way, Your Lordship.
On the way. Okay, okay then, okay. Let them list it.
Tomorrow
Supplementary
will
list.
come.
Okay, no problem. Okay.
Problem.
Item number 8.
My lord, this is an application filed under section 173 of MB Act for challenging the order dated 17/6/2025 in respect of MACT case number 17/2024. My lord, which was dismissed for as a res judicata. So, my lord, if we-
Earlier you received. Or earlier case was dismissed. Or
yes,
what?
my lord, earlier this case was dismissed not on merits. There was not framed any issues. There was no party was contested the
But
case.
it was dismissed.
But it was dismissed. Again, we had filed under order 9 will 4 as there is no any opposite parties. So order 9 will 4, if the case is dismissed, there is then provision as per CPC that the claimant may be filed a fresh list. So
No. Order,
order 9 rule 4.
what is that? Say? What order 9 rule for say?
Order 9 rule 4 says that if a case is dismissed in absence of the defendant,
Hmm.
then the claimant has a liberty to challenge that order or may file a fresh case. So we had
Let
filed-
us see the order.
Yes. My lord, that is that the order was dismissed from the UP MSC because which is given as a
Order 9.
order 9 rule 4.
Have you annexed the order dismissing your?
Yes.
Where?
Page
Let us
number,
see first.
page
that
number
one.
35.
Hmm?
Page number 35. Page number 35. Oh, that is,
Hmm.
he is the not engaged counsel, but he was represent on behalf of you both. From the claimant. The text speaks for passing expertise judgment. While of preparing the judgment, it is found that the opinion is not annexed the necessary supporting documents. There is no documents to the opinion number 2. Ram Chandra is the owner. Opinion number 3 is the driver of the truck. My lord, in that case, we have submitted all the FIRs, copy, postmortem reports, MBI reports.
Read the order first.
There is annex a no motor vehicle report for any charge sheet to prove the accident and that is the case died in the accident. The postmortem report allegedly annexed of the deceased also the name of deceased person substances, but in the written as a non reason. Further from the PM report, it is also difficult to ascertain that the deceased died out of the motor vehicle accident. Further, the claimant has stated in the deceased was the serviceman, but in the FIR it is written as expert serviceman and no any documents is annexed in regard to the income occupation of age. The claim is found have been filed without any supporting documents, subsequently claim, hence the claim is rejected. My lord. Here is my lord. Whatever the documents we have submitted in this case, also I am just annexed in this appeal. Your Honor. So
The claimant, Learned Counsel for the claimant was present or not?
No, not Your Honor. O Boeing, on behalf of on behalf of you, Ori, he is the not engaged counsel.
Maybe, but then it was present only.
Yes.
Okay.
There is no any person appeared on.
That
behalf
cannot
of
be,
the
that
rest of-
cannot be. Today you are appearing, we do not truly engage or not. If we start saying, then
It can be ascertained from the.
see, the
wakalat.
court has no reason to disbelieve the learned counsel appearing on behalf of the party. Today you are appearing.
Yes.
Can I disbelieve you?
No, my lord.
I doubt you have been engaged by your client. I doubt the signature is genuine. Can I say?
No, my lord.
See, we have no reason to disbelieve.
Yes.
So,
So, my lord-
please don't make such allegation.
Yes, my lord. So claimant was present, but opposite party was not present.
You are for?
I am for the claimant, my lord.
Okay.
Yes.
So why you are concerned with respondent? In the presence of the claimant, or this was dismissed?
So, my lord. So even though there is a order 9 rule for we can file in press case. So, my lord, the question is that,
When after dismissal,
yes, my lord. After dismissal, we have filed and press MSCT case before the Honorable MSCT Tribunal, Bomdila, because of the claimant is resident of the Tenga village under the jurisdiction of the West.
wait. Let us see, now come to Order 9, Rule 4. Yes, you have to satisfy how the rule, Order 9 rule, yeah. When the dismissal of suit where summons not served in consequence of the plaintiff's failure to pay cost, where neither party appears suit to be dismissed.
Yes, my lord.
But then here is the
Ex parte
case where the claimant was present.
claimant was present.
Then
So therefore,
what more you want? So after dismissal of this,
yes, my lord.
then again you will file tomorrow.
So there is a
That-
provision, there is a provision.
What is the provision? Please read and explain. Read the provision and explain
Yes, my lord.
how.
I thought that Sito book here, my lord.
Very sad.
My lord.
When
Can it be
you
fixed tomorrow, tomorrow.
you have to come prepared, I
Yes,
think.
my lord.
You have to satisfy.
Yes.
Because if it was dismissed
Yep.
in your absence, then you can only file, of course, for restoration.
Yep.
With reason.
In this,
But here is the case where the plaintiff, the applicant, claimant was present, the learning counsel for the claimant was present, and on appreciation of all those,
yes.
it was dismissed.
So, my lord, there I have challenged that order as well as the dismissal of the MSCT case, which is passed by the Honorable MSCT Tribunal, Bomdila. In a Bomdila, the MSCT case was filed and trial was going on, and after filing all the relevant documents and evidence and cross-examination, then the case was dismissed as a recidivism. So, my lord, so now we can see whether the res judicata is effect or not.
Where is the,
Yes, my lord, the judgment copy. page
Where
number,
the impugn order?
24, page number 24 to 34, my lord. Twenty-four, 34, my lord. The court rejected only on the ground of res judicata. Now that we have to, my lord, consider whether.
Once it was decided, it clearly attracts
Yes, my lord,
section 11.
that is the grounds to legislative, because the debt order is not attracted res judicata. To attract a res judicata, there must be the framing of issues. There must be a framing of issues. There must be a
You could have
Come-
challenged the order, you could have challenged the order itself then. Unless you challenge that order,
yes, my lord.
how can you file subsequent application, claim application?
That will be
Unless
correct.
that order is challenged. If you are agreed by that order, why you did not challenge that order? Have you challenged this order now?
Oh, no, my lord.
How it is possible then?
My lord, kindly can it be fixed tomorrow? That can I will come.
Can fix, but I don't see anything in your case. Better you withdraw and challenge this order first, the dismissal order, first dismissal order.
My lord,
Unless that is challenged, it will be very difficult, even if it's tomorrow, day after tomorrow, even we fix 6 days also. Unless we challenge this, one, because this is clearly, this order clearly says that your application was rejected in your presence.
yes,
You should have challenged this order first.
thereafter already MSCT
And then
case is passed and
now,
judgment is passed.
PC, if you can explain, can you?
Let me pass over this over for transaction.
As prayed for by Mr. B.R. Das, Nana Counsel for the appellant. When?
Tomorrow maybe.
Tomorrow?
Yes.
Tomorrow list already prepared. We'll fix it day after tomorrow. Okay, list is matter again day after tomorrow.
Yes.
Item number 9.
You same, both 8 and 9. 9 is different. Okay.
My lord, in this case, my lord, the honorable tripod dismissed the MSCT case only on the ground. We have not exhibited the RC driving license and the insurance policy, as well as, my lord, there is one just for typical mistakes in the filing of evidence in affidavit.
These are also arising out of the same accident.
Not, my lord.
Okay.
Not my lord. So, my lord, my submission is that, my lord, as the exhibition of the documents, RC insurance is the duty of the owner, because of that the documents is the custody in the owner. We cannot find out that original documents from the owner to exhibit in my case. So only on that ground,
What
for
document?
RC registration certificate of the vehicle and insurance policy of that vehicle. Although we have annexed,
You have filed against whom?
we have filed against the insurance policy as the owner and driver. Owner driver did not contest the case. He declared as an ex parte. So even though we have
It's your case. It's your case. You have to bring a document. You have to produce a document if you want the case in your favor.
yes, my lord, I have also annexed the RC copy and insurance policy there. I have also annexed, because of original copy we cannot exhibit it, because that copy is in the custody of the owner.
Why did you not pray for direction to the owner to produce the original if the court require?
We are legally issued a notice. This is the duty of the owner to furnish the documents before the honorable court.
Okay. Mr.
Dear does, my lord.
Dear Das, Land Counsel for the appellant. This is an appeal filed under section 173 of the Motor Vehicle Act 1988 against, where is the impugned order?
Imping order, my lord, this is the page number from 13 to,
What is this? You have filed this for what? Enhancement?
Oh,
You
yes,
said it was dismissed.
my lord,
Why it is for enhancement? Where is the impugned order?
my lord, page number 13 to 23. Award and enhancement.
It was dismissed only. Why this application for enhancement?
For award and enhancement, my lord. For award-
Enhancement where? Where?
My lord, I have just requested to this court award against the MSCT case and
You have said
whatever.
that enhancement. Enhancement can be done only if you have been awarded.
Yes, my lord.
Here is the case where your petition, claim petition was dismissed.
Yes, my lord.
Then where from this enhancement? Why? How?
Enhancements cannot be done if award can be also done by this honorable court.
Please.
This court can be award. May not be enhanced, but this court can be award.
How it can be enhanced? Unless there is a
Yes.
award. And you are not ready to accept that also. There is a mistake of copy paste. You are not ready to accept that also.
Yes, my lord, this is typical which says that, my lord, this award may be granted. Even though
How this court will grant award?
because of that,
How the High Court will grant award? On what basis?
my lord, that the
Your
case
case is a
case is
dismissed
not, the trial court is not awarded. So we are filing this appeal before this honorable to award and set aside the.
You have not been
order.
awarded at all.
Yes.
How the enhancement? Where from?
That enhancement, it is, my lord, it's typical mistake, but my lord, this court can be award and set aside the imping order.
See, I'm going to grill now.
Yes.
Now on earth.
Yes.
I have understood what the peoples are, what the advocates are. Trying to take advantage of the court, the leniency of the court. Each and every word will be checked now in case of your petition. Trying to mislead the court. In the earlier petition also, we are trying to explain something else. Correct it. Against dismissal. Against the judgment and order dated. When it was passed?
2025.
26/8/2025. Passed by the Motor Accident Claims Tribunal, Bomdila, in MSC case number 12/2024. Whereby the claim petition of the appellant was dismissed. Stop. the appeal be admitted. Issue. And then a call for the record, relevant record, staff, issue notice. Who are the respondent?
Respondent number
Uh,
one and
the- The applicant shall take steps, the respondent by a registered post with steps upon the respondents, by a registered post with AD as well as by usual process within a week from today. So list this matter after 4 weeks. See, Mr. Dar, please be sincere and come prepared with it.
Yes.
It is always better.
Item number 10.
Yes.
My lord has on earlier occasion.
Yes.
Had heard on for considerable time. And now at this stage,
Hmm.
subject to what my learned senior colleague says to object, 4 things has been settled actually. Number 1, the Kaba decision dated 29/5/2025 was not declared on the said Kaba date, but was declared on 9/6, which is violation of 44(1) of AFR. The decision was not declared on the same day, but on the subsequent date when purportedly the Kaba was conducted. Number 1, this is settled.
Just
Number 2,
let us first recall what was the earlier submission.
my lord,
Just a minute. It was decided by the Intervillage Territorial Customary Court.
yes, purportedly, which I'm objecting on jurisdiction.
Okay, the decision was taken on 29.
Not 29, Kaba was conducted on 29,
Okay,
then 7/7 member split decision. Thereafter, on 9/6/2025, they conducted Kaba and
Kaba contacted on 29/5,
yes,
and on that day, the quorum, there's a lack of quorum.
No,
no, no, no. It
There
was
was
a split decision.
split decision. They could not pass decision because Kaba members was 14 in numbers.
Yes,
Seven was in
equal
my
number,
favor,
okay,
seven was-
that case, okay.
Then accordingly, they added another 3 Kabang members and meeting was refixed on to 9th. On 9th, Kabang was held, but decision was passed on 9, but date of decision was mentioned as 29 also.
The
Okay.
executive decision was
So
taken.
whereas this, the rest of, other than 14, rest of the Kaba members were not on 29. They were not yet
No.
appointed, okay, so,
My lord, with regard to the Kaba dated 9/6/2025, there is a joint declaration, a subsequent development,
let us see the documents one by one.
wherein your, my lord, 6 Kaba members have declared that they have not participated in the 6/9/2025 Kaba.
Hmm,
Only those in favor
6/9?
of the, yes, this is the declaration on affidavit by the Kaba member,
no,
who has shown to be attended on the said Kaba. This is the,
no, you have not annexed.
no, this is subsequent development. Recent,
Not in the case.
no,
Subsequent development.
not subsequent
have
development.
managed
Now tomorrow they come there,
Yes.
no, 7
No,
members.
Your Honor,
They-
these
they-
Gaon Burak,
Huh.
Gaon Burak, they are the judges.
Now
As
that
per-
becomes a,
They
have
managed the
dispute of fact.
documents after decision, Lord.
that becomes a dispute of fact again.
Yes, Lordship. But
Now,
on affidavit, they have declared the Gaon Burak. They
10
say
days,
that they
10
have
days.
not participated
Huh.
in the Said Kaba.
Hmm.
However, they have been shown to be participated in the decision. This is a declaration.
Okay, that
On
means
affidavit.
they have lodged FIR also.
FIR subsequently will lodge. You see, this is declaration dated,
You have obtained this,
They will
Mr.
lodge,
First.
yes.
it is declaration, just 3 days back they have declared.
Okay,
After hearing on the 4th, I inquired of my client that whether this happened. So they said, so he informed me that this was not happened. So he inquired whether they have attended. Now they declared that they have not attended. That even on 3rd, only those in favor of the respondent at on meeting 29, they said on the said Kaba dated and they fixed the decision. Wherein one of the Kaba member who drafted the decision on 29, he came, he was called, he was asked to attend the subsequent decision. He said that I will not come because I have decided already given my decision on 29. Therefore, he these things on affidavit, my lord. Serious allegations now. Subsequently, we'll file FIR complaint that will
Now you bring this, and then if you have filed any FIR against that,
that will do.
bring it on record.
This apart, my lord, this apart, at this stage, four factual position has been settled. Number one, on 9, backdated decision was taken. That is not disputed. That is settled. Number two, Parwana was issued on 4/6/2025 for the subsequent meeting of 9. On 5 days was given. That is settled. And the ex parte decision was not taken without giving three consecutive opportunity of being heard. That is also settled. And now the retrospective decision dated 29/6/2025 was pronounced in absence of the petitioner and 3 independent witnesses. These are provided in the act.
For the purpose of disposal of this case.
Yes.
You want to bring this on record, the documents,
These, of course. Your Honor,
not required.
it is factually here not required because I am arguing on law point now.
Okay.
This just to show that how Kaba was conducted. This subsequently will file FIR and complaint. This will follow. The consequence will follow. My lord, with regard to this settled factual position, now, to my humblest understanding, 2 questions to be settled now. Whether Bengal level cover system, which has been declared known as, can on its own assume the power of inter-territorial jurisdiction, customary court. This is one. Number 2, whether the purported inter-village customary cover has exercised jurisdiction beyond vested on them. These 2, if I satisfy this court, then automatically this will set aside. With this regard, my lord, number 1, may I kindly take your honor to section 3 of.
Just a minute, sir. So then in that case, we'll really go by. Where is the impugn order? Just let us.
My lord, impugned order is at page number 49 to 55. Typed copy is 53.
49.
Yes, 49 to 55. Translated
That
copy
translated
copy is at page number 53.
53.
Yes.
So you are agreed by this inter-village territorial customary court.
Yes, my lord.
So where is the original then? This was to be settled by the inter-village territorial court.
What happens, my lord, actually the fact is, in year 2022, one night, my father declared that, in my absence, that he will give these 2 properties to those who will take care of him and my mother in his, olden days. That night, I received a phone call. I called my father and some witnesses that, please don't do that because personal property inherited from our ancestors. So in my absence, this decision cannot be taken. However, my father decided that and they have executed, signed in presence of some witnesses. In that night, 3 witnesses refused to sign because saying that since the petitioner is not there, we couldn't take this decision because this is not your self-acquired property. This is inherited property. So in absence of corporate sinners, such decisions cannot be taken. Thereafter, I made a complaint to the head Gambura. Next 3 days, that complaint has not been taken into cognizance by the head Gambura of my village. Thereafter, they have not, exercising any rights over.
You are the son of the.
Both are son. We both are brothers.
Okay. So you
From same
the
lineage.
father.
Yes, I'm the elder brother. For 2
Challenge the
properties.
father's decision,
Yes, his declaration.
this declaration.
He declared that I will give these 2 property to those who will take care of me in my olden days and all.
And then your the contention is that
My
father
contention
cannot
was,
decide like that way.
yeah, because this is not his self-acquired property. The properties are inherited from the ancestors.
But see, it was inherited by your father only.
Yes, but I am grandson. I have also right over my ancestral property, my grandfather's
It has to
property.
be father.
Yeah, but he cannot decide the co-person's property in my absence. At least he should call all the sons.
Your father inherited it.
Yes.
Your father has the first right.
In any case, Your Honor, this fact,
You are not directly connected with your grandfather.
yes,
Father is directly connected with your grandfather.
but my lord, it is not his self-acquired property. It was acquired by my grandfather.
Where do we find?
So I have also
where do
rights
we
over
find
the property.
Father cannot decide the inherited property in absence of his child.
My lord, that fact apart,
How, no, where from? we
that was,
get this
that
information?
subsequently, my lord,
where from you
subsequently
are-
Kaba decided.
Hmm?
Subsequently Kaba was conducted on 14/9/2022. And the
No,
Kaba
no,
decided in
please-
favor of me.
Let us be clear, because this submission, I am yet to clear about this. Where from you are submitting that in absence of you, the child, the father cannot decide his property like this, the way the manner which he decided.
That is our custom. That is why Kaba decided in favor of me.
Can
In
you
the first
show-
Kaba,
can you
village
show
level
any-
Kaba.
Can you show something on documents?
That is
that-
Bogumboka we have.
Normally, because normally, father has a right to decide in the manner what he wanted.
Yes. He has right, but we have Bogumboka rules and Bogumboka bylaws wherein
You
it is
have one.
provided. I didn't brought it
Now
here.
this has become.
But since the question is not on fact, so question is on law now. That would be settled by the trial court, whether he can decide or not, my lord, in my humble understanding.
Okay, then he has decided.
He has decided
He-
that I
he is
challenge
to
before
be
the Kaba.
inherited by the one who looks after him in his olden days.
Yeah, he has decided
Okay.
that.
And then thereafter,
Thereafter, I made a complaint after 3 days.
what, for decision, he has reduced it into writing.
Yes.
Okay, you challenge this.
I
the-
challenged that and village level Kaba decided in favor of me.
Okay.
Thereafter,
Where is the decision of the father? Let us see first.
that is, my lord, at page number. Annexure 1, page number 19. Translated copy is at 20.
Page 19.
Yes, translation is at page 20.
Hmm.
Declaration. Comrade,
Declaration is a will.
it's almost kind of will.
It's a will only.
Yes,
Before his death,
yes,
the property will be inherited by so and so.
yes.
And-
But that,
Who performs
The
certain duties.
said will also, lordship, for a small correction, there was no specific mention whom property should be given, but
Hmm.
the father,
Yeah.
old age father,
Hmm.
is declaring that,
Whether father is still alive?
no,
Okay,
right.
okay.
Is
just a minute.
declaring that whoever will take care of me
Yes.
and perform last rites will be given this particular plot of land. It
my
was the
lord,
declaration.
my lord, this declaration,
Just
there
a
is also a story, how,
Just a minute.
how he
just
was
a-
made
Just
to
a minute.
declare.
Let us go through the declaration first. Declaration in legal term, I think, since this was his last wish, it will be a will only. Today on so and so. Village elder.
My lord,
Just a minute. Huh? What it says, signature. Further, any document have any thumb impression or signature obtained without the presence of will elder. What is this?
my lord, page 20.
Yes.
Page 20, my lord,
The
which part?
second paragraph, starting with further, any documents have any thumb impression or signature obtained without the presence of
Will. Elders have not,
presence of the sentence probably
yes.
Sentence, yes.
is disconnected.
Basically, he tries to say that if there is any other documents where I
This
have
will.
that will be invalid. That was basically what he declared. But these are, my lord, disputed fact. In CRP,
Just a minute.
we won't go into
Okay.
these disputed fact will be proved, disproved in the cover or in the wherever.
Just a minute,
they
just a
approach.
minute. Huh? So that means this is a last will, what he wanted to say.
My lord, there is a story how he has made to declare
Just
this.
a minute, let us not go to that extent. Let us. He has invalidated all documents, whatever he signed till now, and this is
Yes.
the last will. He clarified.
Yes.
This is a will actually.
It's almost will,
Yeah.
though unregistered.
It's the last. Okay, thereafter, when he died,
That, my lord, I have no idea.
your elder brother,
Yes,
you have no idea.
but I have not asked
Then you are
because
against it.
since these are disputed fact, and in CRP, there is limited scope. Only CRP,
You are not, just a minute, you are not disputing this document, otherwise?
No, I'm challenging this.
No,
I have challenged
this
this, that
document, was signed by your father. This is not disputed.
these are disputed and this is already decided by Kava.
No, no, okay. Let us come, first decide this one. Are you disputing his signature or thumb impression here?
No,
Okay,
but I made a complaint,
okay, but then your,
this cannot
his
be-
declaration is incorrect.
yeah,
actually.
in my absence.
Against the, or in your absence.
And
But the
even,
will is.
even my lord,
How
out
the
of
will-
five
How the
witnesses,
will is to be declared in your presence? He has made it clear that he has declared or signed this will in presence of the elders. How many people?
out of five people, three declined to sign, put their signature. Saying that this is
Who
wrong.
have signed?
Yeah, two have signed.
Decline, not yet signed or declined.
Declined, yes, declined. Three declined. Serial number 2, 3, 4.
How many required as per the law? Two is enough, I think.
Yeah, but since they are also,
Not
Yes,
necessarily three, even if you write.
My lord,
100 also, if two sign, I think
My lord,
it's enough as per the.
but for a moment, just
No, just examine the first, okay? So, yeah, I understood that you have disputed this, but then we need to know the basic, what is the requirement, what it means in the local. This, according to me, this is the last will and 2% has signed, okay?
yes,
Okay, you dispute this,
yes,
and then you against this, you lodge complaint.
yes, a complaint.
Where is your?
That is at
complaint? Let
page
us
number 22,
see. Page
translated copy, 22.
22. This will was signed on which date?
20,
Where do we find the date?
it's at 28/2/2022.
Where do we find the date?
Declaration itself. On dated so and so.
On dated so and so, okay. Just a minute, 22. Okay. Your complaint is dated
22/6.
22/6, after 4 months.
Yes.
Okay, so then when your father died,
That,
when you lodged complaint at that time, he was still alive.
that part I have not updated.
Okay, your elder brother,
Yes.
okay. Younger brother, when he died.
He was died on 25/11/2023.
Okay, after complaint only. At the time of lodging complaint, he was still alive.
Yes.
Okay, then let us see the complaint.
This complaint has not been
Then,
taken into cognizance.
okay,
I
let
mean,
us see.
No action was taken.
Now,
by
let
her.
us see, what is your complaint? Kindly read it.
Complaint for distribution, my lord, 22. Complaint against Sri Mirik Mayi for distributing his property without informing to other family members. Respected AGB, on dated so and so, my father, Sri Mirik Mayi, without informing his sons and other family members, and only in presence of Sri Tumle Mayi, have distributed the ancestral property, and declaration letter made during the night is being objected by Sri Rippa Mayi, and
Who is Ripemai?
I am Rippa Mayi, and son Sri Tumga Mayi and Sri Paluk Mayi, and the entire family members. In that night, Sri Paluk Mayi told my father that such matter should declare when entire family members are present, but not tonight. In that night, Sri Paluk Mayi called me, Sri Tumga Mayi, and we all request my father not to declare such matter in absence of us, but ignoring our request, my father had made that declaration. The declaration letter signed and put thumb impressed by my father at that night is objected by Sri Rippa Mayi and all, declaring that declaration letter as invalid. I submitting this complaint before HGB Nyorak Rakta. Further, I, Sri Ripamai, son of Mirik Mai, further request that from today onwards, nobody should declare anything with regard to ancestral property of us without discussion with the family members. This was the complaint.
So this complaint was not, according to you, not entertained by or taken into cognizance by head GB,
Yes,
Ricky Rime, Rakte village.
thereafter, my lord, from 2022 to 2025, March, there was no activity in that land. But in the month of February,
Meantime, the father died.
yes,
This case was. Okay.
there was no activity in that land. He was not claiming.
How do we know that you have submitted this complaint before the head GB or and the head GB has received this complaint? How do we know?
That receipt is, it's written 22/6/2022, received by Ginyamaye HGV village. It's
Where?
there in page number 21. The original,
Head GB is supposed to call Keba.
yeah, he was supposed to call Kaba.
He did not.
Yeah,
And then you thereafter also did not
but
file any.
he did not, and the respondent, he was not even doing anything over the land. Therefore, I thought might be,
Forget about that. Just let us confirm. So thereafter, so till 2025, you also did not submitted any reminder.
I have submitted that part, you know. Thereafter, there was no activity with regard to that land. Therefore, I was on impression that he is also on my objection. He is also not claiming that. Thereafter, on February, he started doing activities. Therefore, I submitted
February.
again complaint on
Which year?
2025.
Okay, after 22.
Yes. Thereafter, I again submitted a complaint. That is at page number 24,
Just a minute, huh?
translated copy.
Then. This is for what, admission?
Yes. But on last
I
occasion,
think this needs detailed hearing. I was actually going for hearing, detailed hearing. Can we admit and fix it for hearing so that we have a long because it appears that some detailed hearing would be necessary.
I think, Lord, say on previous occasion, it was admitted. If
Yes.
I
Yes.
correctly remember.
If it
Actually,
admitted, then we'll fix it for hearing. Other matters are also there. We can have.
your lordship was
Yeah,
supposed
tomorrow.
to list this on hearing, but since on the request of my
this is-
learned senior counsel, it was again listed on.
Admission, listed in admission for disposal, Lordship. Lordship, otherwise issues are very limited.
Very limited.
My brother is taking from the history. That
No,
the civil, the jurisdiction of civil revision, Lordship.
Hmm.
Lordship, he being aggrieved with the Kavang decision,
Hmm.
interplace Kavang decision. He is filing this CRP on mainly on two grounds. First, for setting aside and passed on 29 by the interplace authority. Then another, he is saying that there cannot be Bango level cover. These are the two issues because there was a place level cover, Lordship. I was aggrieved. Then again, I have filed my statutory appeal before the interplace territorial customary court.
Just a minute.
Till up to the filing of my appeal, Lordship, there is no problem. Because after
Just a minute. Okay, briefly then, after this, your complaint was not entertained. Thereafter, what happened?
Thereafter, I again lodged the complaint on 3/3/2025. That is type copy as page number 24.
Just a minute. Huh? After this, you lodge complaint, 3/3/25.
Yes, my lord. Type copy as page number 24.
What did you say here?
Complaint for distribution of property left by late Mirik Sri Ripamayi and late Ritumayi. I am submitting this complaint that I am the first son of,
You are reprimary.
yes,
Complaint for distribution on the. And then your younger brother is repair.
yes.
No, not repair.
No, exactly not my younger brother. He is the son of my elder
Yes,
brother.
my uncle. My father died.
I'm the younger brother of his father.
See, earlier you said that you are
Yes, my
your
lord.
elder brother. You are not elder brother. Your elder brother, son of that.
I'm
deceased.
uncle, my
You
lord.
are not
I'm
the son
really
of the
sorry.
deceased.
Yes.
You are
No,
your
no.
brother of the deceased.
No, no, no. This is his grandfather, and I'm the son. His father is
Oh,
my.
now again. See, this is what
This is my father, his grandfather.
My father also died, Lordship. Lordship, the Mirik Maya who made a declaration, he is the father. It was his father and my grandfather.
okay, okay.
My deceased father is the younger brother of this present applicant. There was a two son of Ripe Maya who died, made a declaration. and
Okay,
died.
you are the
I'm grandson.
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 Who
Uh,
made a declaration.
he, from the younger brother or elder brother?
Younger brother.
Mirik Maya, Lordship, who has made a declaration. He had two sons. First Ripe Maya, then Ritum Maya. My father also died. I am Tumle Maya, Ritum Tumle. I am representing I pleaded here as a respondent. Gabang was appeal was filed by me. He is the eldest son of that Mirik Maya, who made declaration.
Okay, so okay, you lodge complaint on 3-3. What is
Yes.
this complaint?
Complaint is against same. Submitting complaint, first son of late Mirik Mayan during my subsistence without consulting me, the son of late Ritum Mayi and grandson of late.
But by this declaration, the father, your father has not named any person.
Yes.
Okay.
But they are claiming that. Not named, but they are started claiming that.
Cannot, unless there is a name.
Yes.
It was a with condition. Declaration was made with condition. That
Who
condition
fulfilled
was
the condition?
fulfilled by me.
Fulfill the condition.
Yeah.
No.
No, not necessarily him.
Those are
Yeah,
disputed
just-
facts.
yeah.
That will
And
be
it-
decided
your
later.
complaint is, apart from that, you only say that it can.
Yes. So and so,
father
so and
that-
so, Mayi.
that,
I have
Sure.
taken care of late Mirik Mayi during his aging and performed the last rite of late Mirik Mayi. I had also borne all the education expenses of the orphan children of late Ritum Mayi. Many a times a discussion.
is
Ritu Maya is my deceased father, Lord.
Yes, this is father.
And he's young.
After demise of my younger
you look
brother,
after him.
yeah, I have looked after them. I have experienced the
His
education expenses.
statement, Lordship.
Yeah, this is the dispute. This is why, my lord, I'm saying that these disputed fact will be settled in the appropriate forum.
Okay, maybe.
In CRP, the scope is limited. Whether the inter-village authority, the purported inter-village customary court has exceeded their power, which has been this limited issue. This court has to decide now. Not disputed fact will be settled in the appropriate forum.
Yes, basically what you wanted to say by this, this complaint.
This complaint,
2025.
yes, my lord, this is clear. I'm submitting this complaint that I am the first son of late Mirik Mai, and during my subsistence without consulting me, the son of Ritum Mai and grandson of late Mirik Mai, namely Tumli Mai, Tumga Mai, and Perluk Mai, all is claiming the properties of late Mirik Mai. I have taken care of late Mirik Mai during his aging and performed the last rite of late Mirik Mai. I had also borne all the education expenses of the orphan children of late Ritum Mai, meaning thereby them, the respondent. Many a time and consultation has been tried to make distribution of the family property. However, the grandchildren of late Mirik Mai, as stated above, were not ready for discussion and randomly claiming each property as their own. As such, I am lodging complaint before HGB with a request to conduct village level cover for distribution of the properties. This was my second complaint.
Okay, then.
Thereafter, Parwana issued, meeting conducted, and village level cover.
So this is in person to your complaint.
Yes.
Okay, then.
Then Parwana issued.
Okay, where is
Type
the,
copy 26.
okay, where is the decision?
Decision is at
Kava held.
yes, Kava held, village level
Okay,
Kava.
then where is the decision?
Decision is at page number 33, annexure 8. Typed copy is at 36. Translated copy is at 36.
Okay, this Kaba decision.
Yes.
Let us see, where is the operating decision?
Kaba
What it
decision.
says? Can we read?
Hold,
Yes.
my lord.
Hmm.
Today, on that 19/04/2025, Sri Ripa Mayi, son of late Mirik Mayi, made the complaint for second times, stating that the two sons of late Mirik Mayi, named late Ritum Mayi and Ripa Mayi, both brothers have not yet distributed the properties. Taking cognizance of the same, today under the chairmanship of Sri Ginya Mayi, HGB, a Kaba was conducted. The Kaba members noticed that, one, in the evening of dated 25/5/2022, late Mirik Mayi made a declaration that whoever take care of him shall be given Kesarika, and whoever take care of Srimati Ibom Mayi shall be given Gogirika, land, and Lidirika. The said declaration was drafted by Nyoga Mayi, and during drafting, Sri Ripa Mayi called Sri Nyoga Mayi in his own and requested that in his absence, the property distribution should not be carried out. After hearing such objection from Ripa Mayi, majority of the Kaba members during that night and in the said declaration later, and Sri Paluk Mayi, who was also present during the night, as said that you all are doing match fixing. As such, I am also objecting it to this. After such objection from the Paluk Mayi, Kaba members presents, including Ligo Mayi, Sri Nyoga Mayi, and Sri Mogam Mayi, all did not put their signature. That night, Sri Paluk Mayi also stated that in absence of family members, I cannot accept this. And on the evening of 22/6/2022, Sri Ripa Mayi made a complaint stating in absence of his grandson and sons and other family members, his father late Mirik Mayi has given some properties to Tumli Mayi, which was not agreed. All the members present in the Kaba, after considering all the aspects that only in presence of Sri Tumli Mayi, the properties were given to Sri Tumli Mayi, which was objected on next day. The Kaba found it to be improper and passed as follows. List of properties. List of properties are 9 in numbers. Kesarika was given to Ripa Mayi. I was given Kesarika because Ripa Mayi and Ganya Mayi have opened the WRC field at Kesarika, which was affirmed by all Kaba members. It was opened during the lifetime of late Mirik Mayi for taking care of late Mirik Mayi in his last few years. One land shall be given to Tumli Mayi, son of late Ritu Mayi, for upbringing his elder brother's son and for bearing all the education expenses. Sri Ripa Mayi was given Peta Guga Rika and all the fishing grounds, all properties which have been already left out. This was the decision.
List of properties distributed. 9 properties.
Yeah, out of 9 properties, my lord, Kesarika was given for, because I opened that WRC field. It's written already, the Sharif Kaba. And
Okay, so
another,
out of this 9.
yes, another,
Okay, 9 is the total property.
yes.
Okay,
And
out-
another property that is,
you were given Kesarika and
another property that is Peta Gugarika. This was given to me with fishing ground. This was given to me on the ground that I take care of my these respondents during their orphanage. Because of that, I was given one more WRC land with fishing, that fish pond. That was the decision.
second property, where do
It's second last para of the decision, 37. Sri Ripamai was given Peta Gugarika and all the fishing ground. This was given to me by the Kaba.
all the fishing ground?
Yes.
Fishing ground is mentioned among these 9 items.
Fishing ground is with that particular Peta Gugarika. Adjacent to that, there is a fishing, they have opened.
Not mentioned in,
That's a part of this land.
okay, this Petaguga.
Yes.
Petaguga, no, this is,
Against this, they appeal, prepared appeal in the Inter-Village Territorial Customary Court, Ububango. And the complaint itself says that to the HGB Bango Secretary at phase number 39.
page 39. is
Yes. The complaint was given to the Bango Secretary, not to the Inter-Village Territorial Court.
what? This is the decision of the
Village level kaba. First decision.
Village level ke ba.
Yes.
So, are you agree by this order?
They are agreed, they appeal.
I am agreeable.
Okay, you are agree by this?
Yes.
Because he has been given this.
Kesarika. Especially for Kesarika. Thereafter, they prepare appeal.
Okay.
That is at page number 39 and the type, yes.
Okay,
And the
just a
type
minute.
copy is at page number 40. A translated copy is at page number 40.
Hmm.
To the HGB Bango Secretary, Ubu Bango so and so so and so. Appeal against the Kaba decision of village level Kaba of New York village dated 19 April 2025. I Sri Tumlimayu, son of Ritummayu, on dated
See, when you say very simple, one point, it takes a long time. Okay.
Pilot, may I read the appeal?
Okay, yes.
At page
Page
number
40.
40, yeah, translated copy. Appeal against the Kaba decision of village level Kaba of New York village 19 April 2025. I Sri Tumlimayu, son of Ritummayu, on dated 5
Who is this Tumlimai?
Tumlimayu is my younger brother, his father.
Okay, hey, yes, okay.
On dated 5/5/2025 is lodging a complaint before you, reason that on dated 19/4/2025, a Kaba was conducted at community hall, community there on the complaint lodged by Sri Ripamayu, son of late Mirik Mayu, for the distribution of properties left behind by late Mirik Mayu between the two sons, namely Ritum Mayu and Sri Ripamayu. In the said Kaba, the speakers, while distributing the properties left behind by late Mirik Mayu, have ignored the will made by late was alive, wherein it was clearly stated that the Kesarika, Kesa Jumland attached with WRC field shall be given to one who will look after him during his day. However, the Kaba did not upheld such will of late Mirik Mayu. As such, I am aggrieved by such decision of Kaba, being one who had taken care of late Mirik Mayu till his last death. Further, during the Kaba, I submitted the application requesting the Kaba members for distribution of property and Huga red hunting place after clearing claim and objection for the parties. However, the Kaba did not mention any application in the Kaba decision of 19/4/2025. Therefore, I am filing this appeal against the Kaba decision with a request to admit my appeal and pass necessary order. This was his appeal petition. Thereafter, my lord, Parwana was issued. Re-Parwana and all. After that, I submitted. After that, 29, they conducted Kaba. That is where we come now, wherein there was a split decision, 7-7.
Just a minute. This is Bango Secretary.
Yes, Bango Secretary.
This was for Bango, okay. Then after Parvana, where is the decision of Bango decision?
Decision, impugn decision.
Hmm.
Actually, my lord, what happened? On 29, Kaba was conducted. 14 members were appointed. Actually, out of 14 members, one was umpire. There was 13 Kaba members. However, umpire at the last, he decided in favor of respondent, making it 7-7. Therefore, no decision was taken. Thereafter, Re-Parwana issued on 4/6/2025, fixing the meeting, second meeting on 9/6/2025. On 9/6/2025, only those persons, those Gamburas who have already decided in favor of the respondent, they gathered and they decided a retrospective decision. In absence of those Gamburas who had already decided in favor of me, this declaration on oath, affidavit.
Okay, so 2, 3, 59. This is territorial customary. Okay, inter-village territorial. This is letter addressed to Ripemai.
Yes, Parwana to me.
So this is Parvana.
Yes,
Sorry, Parvana.
they issued Parwana.
Where is the impugn order then?
Impugn order is now at as number 40.
What is 47?
49. 47 is my representation for 9/6 meeting. Whereby I intimate that I will not attend the second Kaba on 9 and cancel the Parwana. However, they have carried out that too in absence of 6 Gamburas. who had,
So this, page 49 is, application written by you. And in
no, page 47, my lord.
page 47
in
is
excerpt
written
12.
by you,
Yes,
saying what?
saying that key inter-village customary court cannot conduct recover. So I would not attend. This is, my lord, in English. In spite of this, they carried out the meeting on 9/9/2025. My lord, that too, in absence of those in favor of me, only the umpire and other 7 members who have already decided in favor of the respondent.
Okay, just, despite of this application written by you, objection written by you, they have
Yes.
decided.
Yes, they
Where
have
is the
decided.
decision?
Decision is at page number 49.
No, just a minute. Here in this application, where have you stated that the KEBA has, does not have the power?
That
Which paragraph?
part, my lord, it is not specifically mentioned,
Then-
since
Then what have you mentioned here then in this?
it's just they cannot conduct second Kava and all,
Where-
majority
where-
was in my favor and all, on factual background. Since they are villagers, they don't know the provision, so they just said ki, we won't attend, you cannot conduct recover. This ground,
Where have you stated?
my lord, that is at paragraph 2, 3, 2, everything is written there. That page number 47, my lord, annex 12. That I am to state that on dated 19/4/2025, a village level Kaba was conducted at Nyorak Rakta village in between the opposite parties in connection with the distribution of ancestral family landed properties. It is to state that the Kaba members had unanimously passed the decision and Kesa land was declared in my favor. Being aggrieved with the aforesaid Kaba village level Kaba decision, Sri Tumli Mai had prepared an appeal before your honorable court, and a Bengal level Kaba was conducted on dated 29 so. It is the aforesaid Bengal level Kaba, the witnesses of both the parties and documentary evidences of both the parties were examined. It is to state that during the Kaba, out of 13 Kaba members, 7 Kaba members were in,
Who?
it's at
which
page
para-
number 47,
Yes, yes.
paragraph 2,
Hmm.
and it is page number 48, evidence of both parties were examined.
Hmm.
It is to state that during the Kaba, out of 13 Kaba members,
Hmm.
7 Kaba members were in my favor and 6 members were in favor of Tumlimayi and Tungamayi. Hence, the chairman would have passed the decision as per the majority, but in spite of passing a decision, a Parwa is good office by adding 3 more Kaba members and fix the date of Kaba on 9/6/2025. It is to state that there is no provision for recover in law and the chairman is not the Kaba member and his duty is to decide the matter as per the majority of the Kaba members. In view of the aforesaid fact and circumstance, I highly request your good office to kindly look into the matter seriously and may recall or cancel your Parwana dated 4 June 2025 and pass the decision of the Bengal level Kaba hearing of dated 29 for the interest of justice. Further, I am intimating you that I am not attending a Kava fixed on 9 June 2025. This is my representation. Submitted on 6/6. Thereafter, in spite of this, my lord, they have carried on with the meeting. That too, my lord, as per this declaration, they shown that, may I kindly take your honor to page number, my lord, to page number 52, wherein they have shown that these Kaba members have attended.
14.
Yes, 1, 2, 3, 4, 5, 6, 7, 8, including him, 8 members have signed in the 29 Kava, meaning thereby 6 other members, they have not attended. And it was in this, with these Gamburas have declared. Further, my lord, one Sri Luyong Sora, who was the drafting, who has drafted the 29 meeting minutes proceedings, has declared that on 3/6 he was asked to visit Bangodere, and since you have drafted the 29 meeting, you should come again on 9. So he said that I will not attend since I have already decided, and he left. In spite of all this, those only in favor of the respondent said declared a retrospective decision. Whereas as per section 40 my lord, as per section, uh, 44(1) of 1845. It's as, my lord, section A per. My lord, section 44(1) of AFR 1945 at page number 6 of AFR, section 44(1).
Yes.
My lord, I have a printed one. It's a page 6. 44(1), hearing of cases, page 6. Last part.
Yeah.
Hearing of cases, all suit tried by the village
This is
authority.
amended or?
Yeah, this is amended, latest one. Hearing of case, all suits tribal by the village authorities shall be decided in open darbar in presence of parties and at least 3 independent witnesses. So it has been violated, number 1. Number 2, my lord, and my lord, as per 2021 Act, AP Civil Court Act, Section 3, 2021 Act, my lord. At Section 3, customary court has been recognized as a lowest formal court, number 1. Number 2, my lord, at phase number 3, Section 11 of APCC Act, jurisdiction of civil courts. Since customary court has been recognized as a formal court, lowest formal court, Section 11 says local limit of jurisdiction. The government may, by petition, fix and from time to time vary the local limits of jurisdiction of any court, any civil court under the Act in consultation with the Guwahati High Court. Meaning thereby, their jurisdiction, their local limits shall be notified by the government in consultation with High Court. No notification with regard to inter-village customary court. Nothing. They are just functioning, number 1. Thereafter, my lord, at phase number 12, Section 17.
Page 12 of?
21 Act, APCC. They are just not to try suits in which they are interested.
Page 12.
Yes, Section 17.
12 is not there. Page 12 of which, have you given?
Sorry, page 4, my lord. Sorry, page 4. It's that I listen.
Yes.
Judges not to try suit in which they are interested. This also, they have blatantly violated. Though, yeah, 17. 1, 2. Thereafter, my lord, 20 22,
No, that is there. How it is connected, this provision? 17. Why you are showing this?
my lord, Kaba members, those were in earlier village level Kaba, they were also part of second Kaba.
Where have you stated it?
That I have stated, my lord, in
Well,
my,
you have to show.
in my plan.
Where?
That paragraph. Or I think in, I have not stated in my,
Then how could?
it's okay, my lord, I'll concede
How
that.
can I find?
Even if I concede that, my
Please.
lord, I have a merit. And my lord, section 44 of paper.
Why you are showing all this?
My, I'll, because
Hmm.
Parwana for the time meeting, only 5 days was given, whereas X provided at least 30 days consecutive 3 times should be given before taking expert decision. Therefore, I am showing section 44 of paper. It's been violated. Section 44. That is in amended 2023. 2023, they have amended AFR. My lord, at amendment number 11, at phase 2 of 2022-23 amendment. 11, amendment number 11, amendment of section 44. In the principal regulation in section 44, after sub 3, the following subsection shall be inserted. 4.
The
village
section,
author- My lord,
section,
section, amendment number 11, section 44. At phase number 2 of 23
have you
amendment.
given here?
23 amendment. 2023, they have amended AFR. 23 amendment. 2023. Notification is 12 April.
Section,
Section 44, amendment number 11, at phase 2.
amendment number 11.
11, section 44. Amendment of section 44. Almost start that.
Yeah.
In the principal regulation, the section 40, in section 44, after subsection 3, the following subsection shall be inserted. Clause 4. The village authority or the inter-village territorial council or apex court, as the case may take ex parte decision if one of the party, disputing party, does not turn up or remain absent willfully for 3 consecutive times after giving not less than 30 days on each occasion of reasonable opportunity. This was not given. 5 days time given and they directly take ex parte decision on 9/6. This has also been violated. Now, my lord is already aware that the Bango level system has been held to be non-est in the eye of law, which was in practice earlier. That is, my lord, may I?
See. It was going, hearing only. That is why it's a best. We'll have to continue it too.
Two, my lord.
This is a full hearing. That's why I knew it that it needs hearing. See, the civil revision petition normally See, it was a full length hearing. It took so much of time, yes.
My lord, I'm now not taking much of time.
Hmm.
I have only two submitted.
What is that?
Number one, my lord, 2016 judgment by this coordinate bench,
Hmm.
wherein Bango level system was held to be non-est in the eye of law.
Which one?
255, 2016. At paragraph
Hmm.
4 and 5, paragraph 7 and 8.
Bango level.
Yes,
So para 7
para
and
7 and 8. Number one, my lord. May I read, my lord, or
just a minute. Okay, yes.
under Assam Administration of Justice Regulation 1945,
Just a
Bill-
minute. 7 and 8.
yes,
Okay, yes, please. Other Assam.
under AFR 1945, the village authority has been recognized as one of the forum for resolving the civil disputes. Apart from village authority, the assistant commissioner, the deputy commissioner, and the high court, there are no other forum recognized under AFR 1945 for resolving the land dispute or river dispute between the parties. In view of the matter, I find that the Bengal level cover could not have assumed jurisdiction to decide the dispute between the petitioner and the respondent, and accordingly, the impugned petition set aside in quas. Number one. My lord, why I'm placing this before this court is, earlier there was a Bengal level which has been now non-est in the eye of law. Now, those Bango has, without any notification from the government, assume or usurp the power and function as inter-village territorial court, which is illegal. It has to be notified by the government, as I have shown, my lord, in section 11 of 21 Act. Government has to notify, number one. Number two, my lord,
Who AFR now says the amended AFR.
no, amended AFR 2023
Hmm.
at
And Civil Court Act.
first, my lord, at amended Act 23 at phase 2, section 5,
Just a minute.
2023 amended, section 5.
22.
Yes. No, 23 amended. AFR amended 23.
Section
Section 5 at phase 2.
amended.
Amendment of section 5.
Section 5.
In the principal regulation, in section 5, after subsection 2, the following subsection and explanation shall be inserted, namely 3. The state government may frame rules and guidelines for all or any as may be deemed expedient, including election, selection, appointment, power, function, and meeting of the head Gamburi, so and so, so and so. Explanation. For the purpose of section 5, village authority shall include members of traditional village council or inter-village territorial council or apex council by whatever name called.
Include member of traditional village council or
Inter-village
inter-village
territorial council
territorial council
or apex council
apex council.
by whatever name called as defined in clause F of section 2. Head Gambura, Gambura and Gamburi institutions, the members of the traditional village council or inter-village territorial council or apex council shall be determined by the head Gambura, Gamburi, and traditional villages head as per their customary laws and practices, and the head Gambura, Gambura and Gamburi shall be appointed by the deputy commissioner of the respective district. My lord, meaning thereby, first, government has to notify as per this section in section 11 of 2021 Act. Government has to notify that this area will be the inter-village wherein the inter-village territorial court will function. Thereafter, the DC will appoint who will preside that as an umpire preside that inter-village territorial council. However, no notification as such from the government. They have illegally usurped the power and functions of inter-village without there being any sanction of law. In this regard, my lord, there is a judgment I have submitted. Whether the question is whether any institution or judicial on its own usurp power and function. For this, I have submitted a judgment of our coordinate bench decided on 8/4/2022 after coming into effect of APCC Act. Chicken Basar son of so and so versus instead of even others.
Mhm.
My lord, at paragraph 4, it is clearly reflected. Then may I read, my lord? Paragraph 4.
Yes.
The respondent number 3, in his affidavit in opposition, stated that the Bengal level cover system is not only prevalent in Galo areas, but also in entire state of Arunachal Pradesh since time immemorial, and the government of Arunachal Pradesh has recognized the existence of such Bengal level cover system by guideline number so and so 2001, and the same was issued to all the district administration and amongst the village authorities, and the deputy commissioner, Laparada district Basel, is within the competency and permitted under so and so. Thereafter, paragraph 5, my lord. In their affidavit in opposition, number 4 and 5, it is stated that village level cover, Bengal level cover, and district level cover are the practice and convention being followed by Adi Galo tribe to resolve the dispute in between themselves, and the cover decision that is so and so. In this case, already notification recognizing Bengal level all has been taken considered. Thereafter, finally, the court decided that at paragraph 11, paragraph 10 and 11, my lord, 12, 10, my lord, at Farah 10. Though the respondent number 4 tried to justify existence of Bengal level cover in the system of administration of justice in the state of Arunachal Pradesh by referring to guidelines number so and so, yet such a provision is not found available in AFR so and so. It is hereby believed that a guideline issued by the government can create a forum which is not recognized under the law. It is an admitted fact that no such provision exists in the AFR 1945 for deciding a dispute with Bengal level cover after a decision of Bengal level cover. Now it is to be seen whether the deputy commissioner so and so can confer jurisdiction upon a forum which is not in existence under any provision of the law. Thereafter, my lord, at 11, while dealing with the issue, Honorable Supreme Court, case of Jagmeter so and so, in paragraph 9, held that law does not permit any court, tribunal, authority, forum to usurp jurisdiction on any ground whatsoever in case such authority does not have jurisdiction on the subject matter, for the reason that it is not the object to place of suing, it is an objection going to the nullity of the order on ground of want of jurisdiction. Thus, for assumption of jurisdiction by a court or a tribunal, existence of jurisdictional fact is a conditional precedent. But once such jurisdictional fact is found to exist, the court or tribunal has power to decide on the adjudicatory facts or facts in issue. It is also indisputably, it is settled legal position that conferment of jurisdiction is a legislative function, and it can neither be conferred with the consent of the parties nor by a superior court. And if the court possesses a decree having no jurisdiction over the matter, it would amount to nullity as the matter goes to the root of the cause. Such an issue can be raised at any stage of the proceedings. The findings of the court or tribunal becomes irrelevant and unenforceable, inexecutable once the forum is found to have no jurisdiction. Similarly, if a tribunal court inherent lacks of jurisdiction, acquiescence or party equally should not be permitted to perpetrate defeating the legislative animation. My lord, though in 2021 Act, the name was mentioned as traditional customary court and whatever name, but it has not been notified yet by the government, constituting the inter-village. Therefore, they cannot usurp the power and function of inter-village territorial court without there being any sanction, without there being any notification from the government. They are illegally functioning, my lord. Not only in this case, in lots of cases, inter-village territorial court without any taking up case and deciding the matter, which will be in days to come before this court. So, my lord, my humble submission, and paragraph 12, my lord.
If the inter-village territorial, if this inter-village, this forum was practicing since
Time immemorial.
immemorial,
Yes,
and then say, for example, in the instant case,
yes, my lord.
if that was earlier recognized,
Yes,
then since the government has, since the law also recognized that it will be,
yes,
except of course for notification,
yes.
except for notification, otherwise, according to you also, this is the inter-village forum.
Yes.
affects
The
all.
government has by notification, they have mentioned as seen in paragraph 4 and 5 of this judgment. However, in spite of this, it was held to be illegal, in spite of coming into effect of the 2021 Act.
Hmm.
Only because paragraph 11, they cannot usurp. It is the legislative intent
Hmm.
to create or to give jurisdiction to particular forum. But however, without giving jurisdiction, without giving any notification with regard to their area, with regard to composition, with regard to their appointment, nothing they are functioning. Therefore, my humble prayer is to set aside and declare this inter-village territory course illegal till the notification by the government, and liberty may be given to the parties to appropriate forum. In this case also, my lord, may kindly see at the page number at paragraph 14
So according to you, this inter-village territorial customary court.
is illegally
So in the
functioning. They have
illegally-
usurped jurisdiction, which is not.
And then
acceptable.
here, the inter-village customary, here, the member of the Gamburas who were earlier as a member of the Gambura in the village level settlement.
Oui.
So they are also, some of the members are also the member of this inter-village.
No,
according to you.
that I have not pleaded in my pleading, so I concede that.
Okay, okay.
Apart from that also, my lord, we have a good ground, because they cannot usurp the power function without there being any notification, any sanction of the law.
Now, according to you, so where should it go? Where
Uh,
should it, according to you, where should they file this appeal?
In that regard, as per my lord, section 9 of section 9 of 2023. My lord, they may approach a civil court under section 24 of AFR 2022 amendment. My lord, may kindly see 2022 amendment section 24. At amendment number 9, phase 2. My lord, 23 Act. They have a remedy,
24 of
23 amendment AFR.
23 amendment
Yes, my lord.
under section 24.
Yes, 24 has been amended.
Section
Phase
24
two.
has been amended.
Yes, phase 2, amendment number 9.
Hmm.
Substitution of section 24. In the principal regulation in section 24, for the existing entries, the following shall be substituted. Any party aggrieved by a decision of the village authority may appeal within 30 days before the inter-village customary court or apex customary court by whatever name called, who on receipt such appeals and dispose. So. Provided that the proceeding in the village territorial customary court, so and so recorded in writing that. Provided that if agreed to by the parties or if agreed party desire to appeal, as the case may be, an appeal arising out of the decision of the village authority or inter-village customary court or apex customary court, as may be, shall lie before the court of judicial magistrate, first class judicial magistrate, so and so, as per pecuniary and territorial jurisdiction. My lord, what I'm submitting now is, when this court declare inter-village as illegal, without there being any sanction or notification of government, then their alternative remedy is to approach civil court. They are not prohibited. They can approach there, appealing the cover decision. Therefore, my humble prayer is, my lord, by setting aside this, liberty may be given to the parties to approach appropriate forum. That much, my lord. Subject to what my friends, senior friends submits.
Yes.
Now, let's see. Fact of the case.
Hmm.
Now, I will only speak from my appeal and then the subsequent development also. Lordship, now here is the case. Lordship,
there was a place level cover. And place level cover wherein some judgment was decided and given in the name of the petitioner. So being aggrieved of that place level cover, have filed an appeal. Lordship, may I take you to my application? I'll show you the only one heading of my application, to whom I was addressed. My appeal. It is page 39 of the civil division. Page 39. Now, Lordship, here, my brother is speaking about the jurisdiction of the Bango level.
This is appeal.
Yes, appeal. This is my appeal, Lordship. This appeal has the decision of the place level cover. Now, Lordship, here addressed to the HDB Bango Secretary, Ubu Bango, Podum ORCC, Mr. Tam, Place Authority of Inter-Place Territory Customary Court or Apex Court. Now, this Lordship, the Inter-Place Territorial Customary Court or Apex Court that has been recognized by the Civil Court Act 2021. Now, it is his submission. I am coming to that.
Okay.
Then, may I take you to this Lordship, one more to the Civil Court, Assam Frontier Administration and Justice Amendment Act 2023. Just my brother has shown you, Lordship. Section 5. May I read?
Yes.
Amendment of Section 5. Now here first for a moment, Lordship, aware that Gauburas are appointed by the Commissioner under Section 5 of the AFI.
Yes.
Assam Frontier Regulation of Justice. Now, that Section 5 has been amended. Now, Lordship, may I read?
Yes.
In the principal regulation in Section 5, after subsection 2, the following subsection and explanation shall be inserted. Namely, the government may frame rules and guidelines for all or any matters as may be in expedient, including election, selection, appointment, powers, functions, and meeting of the head Gaubura, and Gaubura. Now, explanation. Now, after reading this explanation, now the petitioners, they are harping upon regarding the notification laws. For the purpose of Section 5, place authorities include members of traditional place council or inter-place territorial council or apex council by whatever name called as defined in clause F of Section 2 and head Gaubura, head Gauburi, Gaubura and Gauburi institutions, the members of the traditional place council or inter-place territorial council or apex council shall be determined by now. Now, the Gauburas are being appointed by the place authorities are being appointed by the Deputy Commissioner. Now, among the Gauburas, appointed Gauburas, the head Gaubura and head Gauburi of Territorial Customary Court and Apex Court shall be determined by the head Gaubura, Gauburi, and the traditional place head as per their traditional customary laws, and practices, and the head Gaubura and Gauburi shall be appointed by Deputy Commissioner of the respective district. This appointment, Lordship, it's not about the notification and constitution for the head Gaubura Buri of Inter-Place Territorial Customary Court, Lordship. This appointment is regarding the appointment of Gauburas under Section 5 by the Deputy Commissioner. There cannot be second appointment, Lordship, for Gauburas who shall be the place council, place authorities for territorial council, Lordship. There will be conflict then, Lordship.
So, say for example, one village council
Yes,
declared.
Yes.
So you are aggrieved.
Yes.
By that declaration, that, okay, judgment, whatever may be.
Yes.
Okay, my decision, okay. So now, in the village, head Gambura will decide who will be the umpire. Umpire means who will preside over the trial before the Keba.
Yes.
Isn't it?
Yes.
And then this is constituted by head Gambura of that particular village.
No, my
And-
lord, head Gambura himself will act as an umpire. main
Umpire, but then he will have to
Keba
be
members-
assisted by other members also. Who decide who will assist him, isn't it? Not anyone XYZ can sit around,
Only Gambura.
isn't it? Okay. So now, in case of this, then it is filed before whom?
Before Lordship, head Gambura of Banco Secretary, it's,
But there is a Bango secretary.
Lordship, it's name called Bango. Bango means it's a circle, name of the circle.
Yes, there used to be a secretary, Bango
Yes,
secretary.
president, secretary, they have Bango level Gambura Bori Association.
Oh, that is association.
Yes.
No, Lord.
Let him, my lord,
I
I'll
make
just
my-
clarify. My lord, this Bango secretary who issued the parwana, he is issuing the parwana on the strength of being a secretary, not appointed by anyone else. Being only as a secretary, he act as a judge and act as a intermediate force.
Now, just a minute. Under the Act or under the AFR. So Bango, how it functioned earlier? Earlier also it was a secretary
Yes,
who
yes,
issued
Yes.
Parwana.
yes. Earlier it was Bango secretary president, they will functioning like that. They have just usurped the power of intermediate without notification. That is my assumption. Therefore, it is illegal.
Now, according to you, which forum led by who, which authority is legal then is in the Bango case?
That is why my lord, state has to notify.
So
that
long as the state.
They have not
the
any,
state has not yet notified.
yes,
So according to you,
This
it
is
is honest.
you're honest. Because
There has been
section
there has
11
been a
provides that,
decision. There has been a decision.
yes, that is illegal. They have illegally decided. My lord, section 11 of 21 Act clearly says that state government has to notify the area from time to time, their local
see.
limit.
Now come back to this explanation of five.
Yes. As my learned senior counsel submitted, it is with regard to appointment of Gamburas. Even if I concede this, section 11 of 21 Act required that the state has to notify their limits of jurisdiction.
The members of traditional village council, kindly read this fourth line.
My lord said,
The member, yes,
Explanation.
yes, explanation fourth line. The members of traditional, let him read the appellant
the members of traditional village council
slowly.
or inter-village territorial council or apex council shall be determined by Gambura, head Gamburi, Gambura, so and so. And traditional village, head Gam, as per their traditional or customary laws and practices, and the head Gambura, Buri, head Gamburi, Gamburi shall be appointed by the deputy commissioner of
What
the
does it
respective
mean?
district.
What does it mean?
It means, my lord, to my humble understanding, it means that the head Gamburas of the respective villages, they will determine who will be the inter-village member of inter-village territorial
Yes.
court.
In this
That
case-
has to be appointed by the deputy commissioner. At the last stand, that,
Automatically, in all case,
yes,
it will be appointed because
Yes.
the section 5.
yes,
But then here what it says, the members of village council, territorial or the
Yes.
apex council shall be determined by.
by, among them they will determine who will be the, which
And
will be
this-
appointed
this
by
among-
deputy commissioner.
This amount, what you refer to, is being appointed by the deputy commissioner of.
That has to be as per,
They have to determine who will sit as a.
yes,
Bango
my
Keba.
lord, that I agree. But my lord, shall be appointed by the deputy commissioner of respective district. Meaning there are deputy commissioner whom they select as a member, as a chairman, that has to be appointed by deputy. It's a problem. one more line is added there, my lord. At last, shall be appointed by the deputy commissioner of the respective district. If even if they select, if this deputy commissioner doesn't appoint
No.
him or her,
Commissioner under section 5 has empowered to appoint the GB and HGB.
yes,
Whether it's Bongo, whether it's a village level, or whatever may be.
yes, my lord, that is
But
already
it is,
there, not amended.
It is among these village, HGB, GB, that who will determine that who will lead the apex, the traditional, apex body, okay, apex council or the territorial council.
My lord,
Is it not this GB, HGB being appointed by the deputy commissioner?
yes, my
Will
lord,
decide that who will sit as a apex body of the
Yes, my
Bongo level.
yes, my lord.
And then
No, my lord, they are appointed for respective villages. When it comes to between two villages or,
it is, see, the Bongo level, deputy commissioner while appointing GB or HGB, he doesn't appoint for a Bongo.
no,
He doesn't mention.
no,
He only mentioned for the village.
yes,
For this village, he.
Yes, my lord.
Okay.
My
But
lord.
among when it comes to the territorial, inter-village territorial or apex council, then it is only the person of those village head Gambura and Gamburis who determine that who will sit as a apex body.
yes, my,
Isn't it? When
yes,
it
my
comes,
lord, yes, my lord,
A village and B village dispute comes, then the village of this A village, B village, C, E, F, G,
Yes, yes,
okay? Those GB and
Yes.
HGB being appointed by the deputy commissioner will determine who will sit as a Bango Keba, they are
Yes.
in for this case.
yes, my
Is it
lord,
not that?
yes, my lord.
Then,
But my lord, may kindly see, section 5 has not been amended, ever. Just,
no, section
after-
5 is
my
only
lord.
for appointment.
yeah, my
talks
lord,
about
yeah,
only
my lord,
appointment.
I'm trying to satisfy you, my lord, that is already for appointment of Gamburas and head Gamburis
Hmm.
and all. In spite of that, after 21 Act, after recognition of village level courts, why this section has to be inserted? Because this is for the appointment of inter-village, members of inter-village.
No, then in that case, you say, then in that case, this civil court has to authorize again the deputy commissioner and the EAC to decide again.
No, my lord, always, this is already
Yes,
there, my lord. Sale appointment already there in section 5
See,
explanation.
deputy commissioner has the power to appoint Gambura and head Gamburas also.
My lord,
Not
understand.
without mentioning that it is for the apex or
Yes,
the Bango level.
yes, my lord.
They will appoint only for the purpose of, only from the village for the as a Gambura and head Gambura.
Yes, my-
Village only.
Yes, my lord.
But then to decide who will sit
Yes.
for the Bango level Keba, it is only among
Among them.
appointed.
Yes, my lord.
GB
I
and
agree that,
HGB
my
only,
lord. I agree, my lord.
which were who were appointed Section 5 by this deputy commissioner. isn't it?
Yes, yes,
So then in that case, it's not a deputy commissioner who will decide, who will determine, who will be the member of the
yes,
Bango
yes,
level.
my lord. I
It will
agree.
be the GB and HGB who will determine
Yes, my
that
lord.
who will be the members of this Bango level Keba,
My lord.
isn't it?
My lord.
If that is so, then
But my lord, in spite of section 5, without amending section 5, after 21 and 22 amendment of APCC, recognizing village level and inter-village level court, why this section, the legislative intent to enact, why this section is because among them they will select. If that is there, police stop is there, I don't have any argument. But here, shall be appointed, again, deputy commissioner, meaning thereby those Gamburas, whom among them have been selected as a member of territorial, inter-territorial customary court, has to be again appointed by deputy commissioner. The language is this, as far as my humble understanding is concerned, my lord. Otherwise, why should this last line, the meaning of adding this last line? Suppose today we, among, my lord, suppose today, few of the members, they select among themselves one as a umpire. And as per this, it has to be appointed by the deputy commissioner.
language should, supposing what you are submitting, if you interpret, then the language would have been that deputy commissioner will select among these Gambura and head Gambura
No,
as a
that-
member of the.
Therefore, my
member of
lord,
apex body.
therefore, my lord, it is purposefully added, appointed, because 2-3 villages, they constitute inter-village. They themselves selected one. If this act, Gaon Buri, police stop, Gaon Buri, shall be appointed is deleted, then no problem. That will function. But purposefully shall be appointed has been added by the legislature only because that such head of the inter-village territorial customary court has to be again appointed by deputy commissioner, because already Gambura appointment is there, section 5. In spite of existence of section 5, this section is enacted only to facilitate the appointment of the head of the inter-village territorial court. The intent is, to my humble understanding, my lord. Legislative intent is this, my lord. Otherwise, this already there is appointment of the power, section 5. Apart from this section is inserted in section 5, adding. If the intention is to facilitate the constitution of inter-village territorial court, my lord.
Probably it's not what we are submitting. Because this.
Or else,
when
my
after
lord,
saying
just
it-
imagine, my
This also comes only after saying that this HGB and GB.
My lord,
appointed by the
just
deputy
imagine.
commissioner, being appointed by the deputy commissioner under section 5 will determine.
My lord,
Fine.
already they are appointed
By
under
G.
section 5. Section 5 is there, still enforced. In subsistence of section 5, why this section has to be inserted again, added again, only because to facilitate the inter-village territorial court.
So what is your explanation, Mr.? Huh? What is your explanation?
Lordship has rightly defined this explanation, Lordship. That is why, Lordship, before also I have submitted. The intention of the legislators is very clear, Lord. That is why, Lordship, the section 17 in the Arunachal Pradesh Civil Code Act, that is provided. The restriction only provided under section 17 is there. Section 17. Judges not to try the suits in which they are interested.
The section 17.
Section 17 of Civil Code Act 2021.
31.
17, yes, Lord. Section 17, one second.
Yes.
Judges not to try suits in which they are interested. Then subsection 2 also. No judicial officers or authority of customary court shall try any appeal against any decree or order passed by him or her in any other capacity. It means, Lordship, the appointment that is clear, Lordship, under section 5 of AFR, that is appointed by the deputy commissioner. Now, deputy commissioner has, my Lordship has rightly pointed out, deputy commissioner will appoint the Gaubura and Buris for the particular place. And the circle, Pango level, and the circle and inter-territorial based customary court, it will constitute among one circle. There may be 2 villages, 3 villages, 4 villages, 5 villages as per for their administrative convenience, Lordship. Now, place authority, the head, there every place has their own headgum, one headgum, Lordship. They will decide they will proceed and they will function as the chairman. Then first dispute will be resolved at the place level. Then, Lordship, now after place level cover, the jurisdiction of that affiliate authority will be automatically conferred within all the appointed Gauburas, Buris within that circle, Lordship. That is why section 17.2 is provided that says upon first place level cover was done at Norak place in present case, Lordship. All the Gaubura Buris were attended. Now, therefore, the appeal will be within that jurisdiction, that circle. But the Gaubura Buris who attended in the place level cover will not be allowed to sit in the appellate court.
Definitely.
Yes, Lordship. It is clear, Lordship. And regarding jurisdiction under 11, Lordship, may I please to revisit the section 11 clause 2, Lordship. Local limits of jurisdiction, how their jurisdiction will be decided. Civil court, customary court. Section 11. Section 11, Lordship. The government may, by notification, fix and from time to time vary the local limits of jurisdiction of any civil court under this act in consultation with the High Court. Then next, the local limits of jurisdiction of civil court existing immediately prior to the commencement of this act. Existing, Lordship. sale until it is fixed under this act be deemed to be the local limits of jurisdiction of that court.
Okay, what we'll do is probably this involves with the act itself, the interpretation of act itself is another question. So I think we have to go a little deeper into that, in the matter. So we'll admit it and then fix it. And if you this, because we'll have to go deeper into it. And otherwise, it can be a simple case. Otherwise,
Yes.
if we understand, it is only to send back.
Yeah, beside the appeal press,
Decide
Appeal press
if
because
is there.
my appeal was
Order can be passed. But
stipulated right.
writing on that,
Yes.
go for explanation of all those. It will take longer time and because it requires deeper consideration on the matter.
Section 5,
My
my
lord.
understanding, Lordship, Section 5,
So
there is no
because
My lord, may I
statement
kindly
regarding
pray that
notification of
either
the
AAG or AG may be appointed as a amicus curiae for this case. Because if this is not settled, lots of cases will come for the same question.
that is right. That
That's
is
why it's the settle of this,
not that simple.
the amicus may be
Okay.
appointed to assist the
So
court.
no, what we'll do is this is between the party and this case. Okay. Mr. MAK, and counsel for the petitioner. Also heard Mr. K. Lolo, and counsel for the respondent. Upon hearing the party, this court is of the opinion that the matter requires detailed consideration. According the appeal is admitted. Based this matter. So hearing after 3 weeks, 2 weeks, 2 weeks. Okay. Since the
My lord, can we fix a date?
fixed. Okay. Have you challenged this? Otherwise, in the amendment of the section 5 explanation?
No, my lord.
No,
No, not in that.
No.
no,
So then in that, on that they will appoint then? Or what?
Lordship,
Because this is not under challenge.
not under the, otherwise, that's why, Lordship, the question 5, Section 5 does not arise here in the present case.
My lord, not
But
only
then
section 5,
when-
section
when-
11.
When we come to the authority, because he said that according to him, it's non-est, the apex body which has decided. If we are to decide that way, if we are to concede with his submission, then in that case, this explanation will have to be bold. So since he has raised this issue, probably the assistance of the additional advocate general or advocate general would be necessary.
Then may I humbly pray that today itself, Lordship, may appoint them on for next
Yes,
day, because
next hearing.
Okay.
this will be very urgency, in the numbers of cases are pending.
Okay, since the constitution of the
Interplace.
with apex council. No, constitution of the
Interpolace.
inter-village territorial council or
Customary
apex
court.
council, isn't it? Apex
Yes,
council,
yes,
Or whatever name.
by whatever name called is defined in clause F of the section 2. Under question, comma, this court would require the assistance of the additional AG. Government of Arunachal Pradesh. In this case, Stapa, the petitioner shall serve copy of the petition to the learned additional AG within 3 days from 3 working days of additional petition along with the annexure there within 3 working days from today. List is matter after. List page
22 or 23.
List is matter on
22 or 20.
is 22.
Today is 8.
Okay, 22.
My lord,
For hearing,
there is an interim order, maybe continue.
the interim order passed earlier shall continue till then.
Obligement.
Interesting. My lord,
May it be put in on hearing.
hearing.
Oh,
Will it be in the admission or the disposal losses? Because if better to be
Is it?
hearing, it may not arise.
Okay, then admit, leave the admit, okay? For admission hearing, okay? Leave the earlier one sentence, admit one. Okay,
Obliged.
Item number 11.
yes.
May I please, Lordship? Lordship, this is joint petition.
When petition,
Yes, Lordship. Lordship, yes, Lordship. Before your Lordship, offense involved is Lordship, section 77. 6, Lord, 77. Section 79, 66E, 67.
what is 77?
77 is voyeurism, Lordship.
Okay,
Whoever watch or capture
79?
image of woman, yes, Lordship.
79?
And then 79 is word, gesture, or act intended to insult
Okay, that's
modesty of the
66,
woman.
okay, 67, 60.
Yes,
70,
66E,
90. Okay,
and then 67.
okay.
Lordship.
So, charge sheet filed
Lordship.
under the same offense.
Yes, Lordship.
May I, Your Lordship? Your Lordship, in this matter, there are 5 complainants, Your Lordship. But Your Lordship, including the petitioner number 1. So, and Your Lordship, they have not implemented the rest of the complainant as a party, Your Honor, Your Lordship.
Okay, you are for?
For the victims, Your Honor. In the first charge sheet, they have not mentioned the rest of the complainant, although they have annexed the FIR of the rest, Your Honor. So they have they have not taken any concern or knowledge of the other complainants, and they have filed this petition.
Other complaint
Yes, Your Lordship.
is also clubbed together or investigated together.
Yes, yes, Lordship. And supplementary charges has been submitted, Your Honor. So,
Supplementary charges.
yes, Lord. Supplementary charges has been already submitted before the JGB board, and Your Lordship, on behalf of the rest of the complainant, I'm filing wakalat nama, Your Lordship.
If Lordship, I'm not aware about the supplementary charge sheet. If they have, the IO has filed supplementary charge sheet, then I need to apply the charge sheet and go through. Then after I will pursue my case. Because Lordship, initially the complaint was lodged by the present petitioner number 1, and the settlement arrived between these parties. And the charge sheet, the charge sheet filed by the IO is in respect of the FIR lodged by the present petitioner number 1. Also. Otherwise, Lordship, if there was other complainants and their case
Club together.
Club together,
Yes,
then
sir.
of course.
Let us see the supplementary charge sheet. You have annexed the charge sheet, otherwise the earlier one.
Yes,
So this is under the same offense.
yes, under the same offense. Lordship.
Okay. Let me-
We'll call for the updated case study, Lordship.
So let us see if there's is separate investigation carried out.
No, Your Lordship, actually, no, their name should be reflected in the same charge sheet. But the IO, they have not mentioned the name. So we have submitted the representation where their name has not been reflected. So after that, they have submitted.
Now, where is your document? What is that?
Wakalatnama, Your Lordship.
Wakalat nama?
Yes, Your Lordship.
No, why you are submitting wakalat nama here?
It is how
Where is the supplementary charge sheet?
Your Lordship, a supplementary charge sheet is in the JJB board, Your Lordship. So,
Actually, this is Lordship, JJB board Lordship, on last occasion, they Lordship already submitted this first charge sheet to JJB board Lordship. So JJB board, yes, Lordship. Lordship, first charge sheet, already,
Charge sheet already submitted.
yes, Lordship,
Yes.
before the JJB board Lordship. Then Lordship, as per this, her statement now that supplementary charge sheet is already been Lordship submitted, that I have also
No,
no idea.
whether, where is the charge sheet? Can we see? Just charge
That's
sheet,
it,
whether
Lordship.
you have annexed.
Yes, in additional affidavit. In fact, Lordship, my criminal petition was filed during pendency of the FIR investigation. Just after 15 days, settlement was entered.
Because supplementary charges, unless he keep open for filing of supplementary charges, he cannot.
Your Lordship, their FIR has been lost, FIR has been annexed in the main charge sheet, Your Lordship. FIR has been annexed in the main charge sheet, Your. Yes, FIR is there. The rest of the complainant FIR has been annexed in the main charge sheet, Your Lordship. But thing is that only the name has been missing.
So entire charge sheet, Lordship,
No, charge me.
where is their name? I am asking about the name. Nowhere it is reflected. Maybe her statement may be true, but Lordship, this in present, it's my Lordship to go for the charge sheet.
Then Lordship, kindly Lordship, then all 40 Lordship
No.
updated.
If it is not connected with, how do we call?
Lordship,
In the case which is not connected with, if that is a separate case, we cannot call.
Your Lordship, it's connected. It's connected matter, Your.
Understand. Okay.
All the complainant FIR has been annexed main charge sheet, Your.
All the,
FIR.
you did.
Yes.
Annexing of complaint, Lordship, but after completion of the investigation.
No, see, in the charge sheet, the IO has, as I said, that prayed for, he has kept open
Yes,
to submit supplementary charge sheet.
that is regarding the FSL report, Lordship. Is received and
Yes, that is
section under IT Act is yet to be proved based on the FSL report.
FSL is received. and
Because
the
they-
Section IT Act is.
Yes, Lordship.
Whether the
Since-
other FIR are also there.
FIR is there. In page number 30, in practice. Committed by the police.
An entire charge sheet, Lordship, the first charge sheet, there is no whisper about the subsequent FIR and registration of FIR. That might have been registered separately, then investigation might have done separately, and their charge sheet has been filed.
Your Lordship, same case and same victim, Your Lordship. There is not only one victim, there is affected by the three victims, Your Honor. Your Lordship. So they have they have lodged the FIR. At first, Your Lordship, they together lodged the FIR, but the instruction given by the police station that they cannot give the same FIR in the same place. So because of that, they separately gave the FIR, Your Lordship. Affected by the same incident, Your Lordship.
if it is, Lordship, coming up from the same FIR Lordship, then it should be clubbed together Lordship, if the FIR is same Lordship.
Let us see if there is any record.
Only. Okay. Right. So, again, it is not instant because it's a great. Katrina. Fair was the thing. The FI number for me. The FI to another one. What's the thing FI to me? It's not another one. Forward. It's 53 how to fill the plan and pay the rest. Look, women. That is not taken into what is happening. Okay. But it's for the moment. That's for the matter. It's for the advertising. It will be done as what we know. It's like that's for the matter. That's no plastic in.
See, there is FIR, it appears, that's it. And an FIR, not registered, but it was received by the IO. And it has been clapped, but why? And there, statement also recorded, it's same only. But then in the agreement, you have entered into an agreement with only one appears.
Because, yes,
So then they are also necessary party. Because if it has been clapped,
the club and charge sheet has been filed on their complaint, of course, lordship, they will be necessary.
mhm. So their names are there. They are also informant, huh? And then in the charge, have you gone through the charge sheet?
Yes, lordship. Initially, I am not aware about the supplementary charge sheet, lordship,
Mhm.
but I have enclosed
You made a prayer for commission supplementary charge sheet. because it
Supplementary,
is connected
yeah.
with, of course.
that is also in respect of official report.
But then probably he must have collected all the documents and then sent at one go.
That is true, that is true.
So then in that case, probably you may have to, even if there is an agreement,
Yes.
it has to be with all. And if it is setting aside, it has
Yes.
to be with regards to by mentioning, and they need to be informed.
Yes,
Notice need to be given.
yes, yes. In that
So-
case, lordship,
Hmm.
I may be allowed some time so that I can obtain the supplementary
Okay.
charge sheet and go through whether any materials in respect of their complaint has been filed.
Hmm. Okay. You B, Memo, Land Council submits that. There
Today,
are other,
no-
how many more you said? Two more. Four more.
For FIR.
I could see only
Three
two.
are, your lordship, three are victims and one is the complaint for another case. But in the, it club in the same,
No,
Okay.
here, in
Yes.
this case,
yes, sir. Four.
don't give like this. You give this wakalat number before the registry. Don't give it
Oh.
before the court. Huh?
Please.
This is inappropriate. Huh?
Today, Lordship may, small prayer. Today, if they file a wakalat number today, tomorrow, if I go through the charges, and if I supposed to be at a settlement, then it may be difficult for the petitioner because their name will be reflected as the respondent. Because in this case, they are not the respondent now, as of now.
No, here actually, if this has been clubbed together, because if it is the IO,
Yes.
I have not gone through the entire records, but then Planet's additional PP will go through. If somewhere, if they have already given a statement in this case,
Okay.
and
Yes, statement is
It-
there, lordship. Yes, lordship.
if this was investigated together
Yeah.
along with the present FIR, against whom the against petitioner has filed.
Yes, Lord, yeah, statement, lordship, it's revealed out of the same
then it is,
incident,
then
lordship.
it
Yes,
is out
lordship.
of the same. Then,
Yes, Lord.
then in that case, they are necessary party.
Necessary, not
Same house, same house,
Hmm.
same house and the,
The FIR also laws at about same time.
yes,
Okay. Some is that there are. Yes, some is that there are other, how many FIR? Two? Three FIR?
four.
Four? No, yeah, I could see only two.
Your lordship, there are in, 4 FIR.
No, in this petition, lordship, there are two lordship. In this petition, current petition, they have made party only two members, lord.
There are other victims who had lost. FIR against the child in conflict with law. And the which were clubbed along with the present along with the present case. However, in the application, the petitioner has not made them as necessary party. Stop in this in view of the above submission of Lanet Council appearing on behalf of Lanet Council, Mr. Lowland, Lanet Council for the petitioner, prays for some time to obtain necessary instruction in the Miss El Hajar, Lanet additional EP also prays for some time to go through the records.
Lordship, we have to call records from the
In
juvenile.
in her submission, they are not clubbed together along with the present FIR. And subsequently, the IO of the case has also filed supplementary charge sheet in the case. Okay, then in that, the prayer is allowed. Stop, Are you sure that the supplementary charge is already filed? So have we called for the record or the CD?
We have to call the record because lordship is already submitted before the juvenile,
Where from? did we call?
JJB lordship.
Yeah.
UPL lordship.
Record was called.
From the juvenile board
JJB
lordship, JJB UPL. From the office of
It
JJB
was
UPL.
called for case diary only.
It was before submitting of charge sheet, Lordship.
Okay,
It was
then
earlier stage. Lordship.
subsequently record a call for,
During pendency of years, this application charge sheet was filed.
just a minute. Okay. It was a preliminary report. Whether this is preliminary inquiry report or what?
Lordship,
Hmm?
they have made some observation, Lordship, because that charge sheet, Lordship, after receiving charge sheet, they must have made some observation.
Okay. In her submission, huh? From there are other after that, no? The plea has also submitted preliminary police investigation report before the it's JJB or
Yes, sir.
before the principal magistrate, juvenile justice board, UP, Papumpare district, capital complex, UP,
Yes.
Okay, then in view of that, no? Mr. Praise for some time. Time, prayer allowed, huh? After that, the priest will get it, and the CTC 8 like it. 2 weeks. Then it's a break the idea. In view of the submission made by the Land Council for Land Council Minister and so, let the entire record, including the supplementary charge sheet, be called for from the principal magistrate. Okay. JJB Papumpare. This is scan copy.
Lordship, it must be scan copy,
Okay,
Lordship.
let us scan copy, huh? Be called for, huh? Okay. And then after receipt of, after confirming the parties, you can impede
Yes.
them. List this matter after
2 weeks, Lordship.
after 2 weeks.
Yes.
Okay.
Obliged, Lordship.
Item number 12.
We have not received the TCR yet, Lordship.
Okay.
Scan copy, please.
So which court?
Your Honor,
Daporizio.
Daporizio, Your Honor, CGM court.
Original was called
No,
for
no,
or the
Lordship,
scan
the-
copy.
In the session,
Session.
Court.
alo, Lordship.
Ala.
Basar paper, Lordship.
Session, then it's hello or Basar. Basar.
Yes,
Basar, yeah.
Basar, it's-
Now, Allah is taking in charge of
Daporizio,
Basar.
So the case was already charge sheeted.
Yes, Your Honor. So, Your Honor,
There is no-
I saw-
Basar.
my lord,
Mr.
I am the Italian Sorum Tamil,
Okay, Land Council.
representing on behalf of the petitioner, Your Honor.
Okay, Land Council for a petition or present.
Yeah, my lord.
Miss L. Hage, Land additional PP. Raised for, submits that the PCR is called for has not yet proceed and pray for some more time. How much time?
uh, after a week, next week, then Lordship.
No, I think the TCR was called for. We can call for the scan copy.
Yes, Lordship.
Okay, let
Your-
scan copy of the trial court record.
My lord, may I
The-
submit, because
record
this
that
is,
they call for
I'm
from-
saying-
what you want?
I want, my submission is that this is.
What submission? Record is not yet come. What can we
Record.
do now? What do you want to
Because
submit?
this is a case of your medical, depart from the Daporizio to.
Maybe, but we need to peruse the record. Record is.
In this situation, interim maybe grant to,
in the-
interim.
In the case, then you have to file separate application for interim if there is an urgency.
Because,
You
Yo,
please
my-
don't submit like that.
my lord,
As if you are
because
not advocate. You are advocate.
he has been, generally custody since 6 months. And he has been,
What is the offense?
offense is, you're not,
What you want your
my
client?
lord, 3, attempt to murder and cause grievous injury,
Huh?
109 and
What is
108.
109
Attempt to
and what is 118?
cause grievous injury.
See, then
So,
press for some more time. Huh? So, the prayer is allowed. Let issue reminder for scan copy of the trial court record. The registry.
my lord,
Registry shall issue
better we
reminder.
fix early because
Please.
better we
Why
fix.
you are disturbing? Don't disturb like that. For the scan copy of the TCR. Issue reminder, for a scan copy of the TCR from the Court of Additional District and Session Judge Prasad. Yes, what do you want? Is this matter after a week?
Lordship, if it is just
Within-
medical ground, then within
within-
this week, it can be.
Within, yes.
Friday?
Lordship.
Okay, then fix it up. List this matter on Friday is on 19th. Okay.
12, Lordship.
Oh, sorry. 12. Yes, anything? Okay, but while dictating, please don't disturb.
Always.
Yeah.
Okay.
Yes.
Item number 13.
Yes.
So this is the matrimonial against the ex parte decree passed by the Lana District Court.
Okay.
On the last occasion, this honorable court was directed both the parties. Mediation.
Yes. What happened then?
In compliance with that, that's it. I think a petition, we are ready for settle the matter.
Okay. And you?
Lordship, I am for respondent. So, Lordship, we are not ready for settlement.
Why?
So, actually, Lordship, respondent,
You are for husband or wife? You are for husband.
I am for wife.
The appeal is. You are challenging which order?
The appeal is, I am challenging the divorce
Divorce already.
decree and order passed by district judge on dated 24/2020.
Challenging the divorce the decree of divorce,
Yes, it was passed ex parte.
ex parte.
Yes, actually, I am totally unaware of the.
That is not possible again. You are blaming, now you are blaming the court also.
Lordship, there is a record.
Hmm.
There is a.
What interest the court has to decide
Lordship,
ex parte
they-
without serving notice?
Yes, the notice was not being served to the respondent. That is,
Divorce granted. So how, when you got married?
I have married, I have a. Lordship, I have filed in
No, when you got married, what? Which year? Any children,
yes,
issues born out of? How many children?
one,
Okay, when separated?
2000,
12 married. Since when both are staying separately?
2000.
16, and then now it's 25. 9 years. Okay, now she don't want to come. Okay, now you are married.
No.
She is married.
That-
No, you
But I have paid,
any alimony, permanent alimony granted?
no,
You object the decree of divorce. Why you want to disturb?
Lordship, yes, because.
Because you are not staying for 9 years. Children is with whom? Child is with whom? With you. Then what interest you have?
Lordship, because the decree passed by the London Trial Court.
Huh.
Yes, because
Now,
I have not been given a form to contest it. Yes, because Lordship, I have filed an application for condemnation and the same has been granted by the Supreme Court on showing sufficient ground for filing of the present matrimonial act.
you prayed for filing, allowing you, have you filed affidavit in opposition?
No, Lordship, on next date, we'll file.
They have taken so many things.
See, when you're appearing, and you should file. You file, we'll decide next time.
On next date, Lordship will file.
You file within a week, because it seems that you have taken time.
We have served copy to them who in 2024, 14,000. But since then, they have not. filed. The matter has been already confirmed by showing sufficient proof.
Okay. See, 754 days conduct.
It has been confirmed. And Lordship, if this honorable court is giving an opportunity, mediation, of the time, I'm ready to talk with, but the thing is that he has,
So he has an objection, instruction not to go for mediation. Why can't you go for mediation? You don't want. But we can't force also if you don't want.
it is there, but
Let them file a affidavit then. In that case, we'll decide on merit. Okay,
Yes.
we'll decide on merit. Okay, if he is not ready,
Lordship kindly parents last. They had taken long time. So last opportunity. If they,
Lordship, 3 weeks time may be given to us to file affidavit.
long time. (22/10/2024), we have served notice. Since
Hmm.
then, they are. Yes. 22nd October 2000.
Kita Land Council for the applicant staff. I've also heard Mr.
Emata.
M. at the Land Council appearing on behalf of the sole respondent who prays for further 1 week time to file affidavit in opposition staff. The respondent is given one last opportunity to file affidavit in opposition. Stop. In case the affidavit, the respondent failed to file affidavit in opposition within a week,
Lordship, kindly,
within 2
Lordship, 2 weeks may be
by
given.
the next day, the matter shall be taken up for hearing dates, taken up for. So the matter shall be taken up, matter shall be taken up for, not for hearing. Okay, matter shall, all endeavors shall be made to dispose of based on the documents available on records. Yeah.
Yeah, delay.
Highly obliged.
Item number 14.
Lordship, I am for the petitioner, Lordship.
Yes.
We will take fresh steps upon respondent number 1, 4, and 5.
Okay. Not yet taken.
No, Lordship, there were some issues.
Mr. Pine. Pine, huh?
Yes, Lordship.
Planning counsel for the petitioner. Raised for further, how much time? 1 week time?
2 weeks, Lordship.
Further 2 weeks time. You have taken long time. Further 2 weeks time to take fresh steps upon the respond. How many respondents?
In total, 5. But we will take steps upon
1, 4, and 5.
Yes, Lordship.
1, 4, and 5. Prayer allowed. Steps upon the respondent number 1, 4, and 5 by a registered post with AD.
Yes,
as well as by usual in a week from today. List is matter after 3 weeks.
Deeply obliged.
Item number 15. My lord, I'm appearing on behalf of leading counsel Emi Talum.
Okay.
Honor, earlier I have prayed for the adjournment.
Okay. It was not granted.
Yes, Your Honor.
Okay. Now you want the adjournment to be granted
Yes,
to
yes,
you.
yes, Your Honor. Because Your Honor, leading counsel held is
What
not.
is this petition about?
Your Honor, it's joint petition for quashing and setting aside of GR case number 243/23.
So you know something about the case, your case?
No, Your Honor. I have only been instructed to adjourn the case.
Don't do that.
No, Your Honor,
When you are
earlier,
you are instructed to adjourn the case.
yes, Your Honor. Your Honor,
come
earlier,
along with the brief.
Your Honor, earlier interim was granted. So that may be continued.
Why? It's 397.
Yes. It's a serious offense.
Hmm?
Robbery or deceit with attempt
cause death or grievance. Next time you come prepare. We'll dispose.
Sure.
Report has also come. Yes. Okay. Mr. You are
tea time.
Hmm?
Tea time.
T. Tying, Land Council for the petitioner, praise for why you are seeking adjournment,
Your Honor, because leading counsel
Mr.
Held is not good,
Land
sir.
Council, some is that the leading council, he's senior, the leading
Yes.
council. You are Bhutia. Land Council for the petitioner is out of station. Therefore, pray for adjournment of the matter, to which Mr. Loilana PP has no objection. Prayer allowed. This matter after 2 weeks.
Right.
Item number 16,
But this is 15. 15. Okay. Senior, yes.
Service report awaited, Lordship.
Okay.
In respect of
Taylor and Land Council for the petitioner is present. Service report on the respondent number 1, 2, and 3 is still awaited. In view of the above, let this matter be listed after 3 weeks.
3 weeks.
Okay.
Lordship, there is an interim order.
Okay, in the earlier case also, the interim order passed earlier shall continue till the next day. They're also same. Okay.
Deeply obliged.
item number 17 and 18.
My Lordship, leading counsel is unable to attend today due to medical problems on behalf of TTAPA. So matter may be listed after 3 weeks.
Is this matter above?
Challenging the impugn order.
What is the impugn order? Mr. Taba, you are for respondent.
Yes.
What is,
There is a impugn order dated 27.
what is this impugn order about?
Lordship, there is a two accused person in this.
By the impugn order, what?
Yes, the co-accused person has been discharged by the learned trial court during
Okay.
the framing of charge.
Okay.
So they are challenging this.
The discharge,
Yes,
discharge order.
discharge order. They are
Okay.
challenging the discharge order of co-accused person.
Okay, then in that case, you are the person who have been discharged.
No, yes, yes,
Discharged under what, for what offense?
for want of sufficient materials.
Okay, what is the allegation? What was the allegation?
For abatement, for abatement.
Abatement,
Abatement.
306
No,
IPC.
for abatement of commission of rape.
Okay,
She's a lady.
so you are lady. Okay. Okay, which case this is?
And Itanagar, WPS case.
Okay,
The accused person are husband and wife.
okay.
Lordship.
Accused persons are husband and the
Wife.
person who make an allegation is third party.
Yes, that part.
And she says the wife abated
Yes,
and then
abatement.
husband committed.
Yes,
Major, minor,
all major.
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 Okay. Then you next time you come prepare,
Yes, Lord.
even if your senior remain absent also. Okay.
So see, for the third time they are taking adjournment.
See, maybe for some reason.
It seems that Lordship,
You're Mr.
B. Sibo.
B. Sibo, Land Council for the Land Council is senior is
TTAPA.
what happened to him? You said
Medical problems.
okay. Has is indisposed. Therefore, pray for adjournment. To which Mr. B. Taba, to which Ms. L. Hage, Land Council appearing on behalf of the other side. There's no objection. Prayer allowed. This matter after 2 weeks, 3 weeks,
3 weeks.
3 weeks.
Yes.
Okay.
Item number 19,
Lordship, in item number, Lordship, I am the petitioner. And in this case. there
This is
a-
with only 17, 18 is with
This is Lordship
17.
criminal petition number 31. In criminal petition number 31/24, here is a stay order, Lordship.
In 18,
Yes, yes.
okay, then,
Stay order dated one four.
Mr. Vitava, Land Council for the petitioner
be
is present. Mr. So-and-so seek adjournment of the matter. Prayer allowed, This is matter after, we said 3 weeks. 3 weeks, stop the interim order pass earlier shall continue till the next date of this. Okay.
Yes, yes. Date.
Item number 19.
My lord, I'm appearing for petitioner. My lord, the service report has come just to provide a brief context of the matter. My lord, I'm challenging an order of the learned trial court whereby the trial court has refused to delete. Trial court has rejected my application seeking deletion from the suit. So my lord, after the last order, the service report has come. As per the service report, the service has returned for respondent number 2 to 8, which are in any case pro forma parties here. And for respondent number one, which is the contesting party here, has filed a wakalat now.
Okay.
So that is the party. So my lord may fix
So
a date.
what do we do with this other respondent whose notice has returned unserved?
My lord, may allow me to take fresh steps on the alternate addresses, my lord. So I'll provide fresh addresses, and in the meantime, before the next hearing, we'll take fresh steps for the pro forma parties. And for the next hearing, my lord may fix this for the arguments of interim relief. Because he's the contesting party.
Lana Council could appear on behalf of the respondent number 1.
Yes, sir.
You have filed wakalat nama?
Yes, sir.
By staff. In view of the office note dated 6/9/2025, Mr.
Tejpal Singh Rathod.
Lana Council for the petitioner prays for allowing him to take fresh steps upon the respondent number 2, 3, 4, 5, 6, 7, and 8 in their new address.
On alternate address or on different
okay.
addresses.
Okay, in their alternate address.
And since
Yes,
since the main party, contesting party is there, next hearing may be fixed for the arguments on interim relief. Because the other respondents anyway, the pro forma
the
party.
prayer is allowed. Steps upon the respondent number 2, 3, 4, 5, 6, 7, and 8 within a week from today. Within a week.
Within 2 weeks, my lord,
Within 2
and
weeks,
if
yeah.
the date may be fixed post puja.
Stuff, This matter. When? It will be after.
After
within
break,
2
after puja break.
My lord may put it on October 24 or October 28, whichever is convenient.
on age prayed for Kama. This matter. Again on
24th October if convenient.
okay, 24 October. Okay.
Yes, grateful, man. For consideration of interim
Step
relief.
by register post with AD, as well as by usual process within 2 weeks. Okay.
My lord, interim may be considered on the
The
next.
interim order passed earlier shall continue till the next date of this thing.
There
Okay.
is no interim
My
order.
apologies.
There is no interim.
Interim may be considered on the next.
Okay. On which date
On the
the
next.
interim prayer shall be considered? Okay.
Grateful, man.
Item number 20.
Yes.
Please, your lordship. Your lordship, TCR was called.
What is this matter about?
It's for your lordship, for quashing on agreement, your honor, on settlement.
What is the offense alleged against the accused?
Your offenses. It's robbery, your honor, 392.
Where is the allegation? Let us see the FIR.
Yes, sir.
So all parties are present.
This is joint
Joint
application.
petition.
Joint petition, your honor.
Robbery, okay. Where is the FIR?
FR is on page 44 and type copy is
Why
in,
it has gone to 44?
type copy is in page 45, your honor.
FIR is supposed to be the first annexure. Why it has gone to 44?
It was assembled with the charge sheet, Your Honor.
Charge sheet filed?
Yes, Lord, sir, charge sheet is filed, and the matter is pending in the stage of evidence. However, Your Honor, no witness has been examined yet.
Charge frame
Yes, Your Honor.
under same offense, 447, 354, have you annexed? Okay.
Yes, Your Honor, same offense. 447 was dropped, trespass.
Is there any stay?
Pardon, Your Honor.
No,
Is
Lordship.
there any stay or not? No.
No, no, only scan copy of teacher was called for.
Also, no stay.
No stay order. Your Honor, since no witness has been examined yet, and the complainant has come into set with the accused person, so there is a very big chances of prosecution, Your Honor. And the victim has been satisfactorily compensated, Your Honor.
He has already given deposition, victim.
Yes, Your Honor. The complainant has given both 161 and 164 statement also.
164.
Yes, 164 is also.
This is 164, you mean to say?
164 statement is in page number 18, Your Honor.
Okay.
Yes, page 18.
This is 164.
Yes, this 164 before judicial magistrate first class 164.
When this incident occurred, which year?
It's 10 years ago, Your Honor, 10 years case, 10 years ago case. It's on the 15 case, Your Honor, 2015 case. And both the parties, they are, at the time when the offense was occurred, they were very well acquainted to each other. Running same type of business, Your Honor. Unfortunately, when the offense occurred, the accused person was under the influence of alcohol, Your Honor.
In her statement, she did not say anything about that, no whisper. Yes, what do you say?
Lordship, as per the lordship, I have gone through the statement of the victim, lordship. That she has recorded this statement way back on 2015. And they have come into settlement 2025, lordship, lordship. Might have they, in the between they have compromised, lordship. And moreover, here, lordship, the injury also simple in nature.
Where do we find the
Injury, I have just gone through this page 33, lordship. And in the their compromise lordship, that agreement also they have reflected that they have already compensated the lordship, lost item lordship. So lordship, if this is the case lordship, if the proceeding will lordship allow, then it will be total excess lordship, as per query submitting lordship. If already it's settled lordship,
where is simple injury?
lordship page 33.
Previous pain. Okay.
Impression is simple injury. I would also like to add that the accused person, he has no history of criminal antecedent, Your Honor. This is the first case, and this case was built up on misunderstanding, Your Honor. So
No, he snatched away the golden chain also. How it is assaulted.
and the main item, which was the focus of robbery, Your Honor, that item was also not found and seized by the investigation authority, Your Honor. And even
You tell where you have kept. Unless you tell where, how the,
so
you will.
there was a scuffle between the parties, and during that scuffle, it broke. So
See, it is probably have to be there on the spot. It could never be found out. And according to you took it away. And if you hidden it to somewhere else, how do you expect the IO to find it out?
so
Mister, you are Mr.
PC guy, Your
Hmm?
Honor. PC guy.
P. Siga, Learned Counsel for the petitioner. I've also heard Mr. Hage, Learned Additional PP for the state.
There's also an absence of mens rea also. Intention was not there. He didn't go to that restaurant to.
I'm not this person. This application under section 528 of BNSS 2023 has been filed, has been jointly filed by the who is accused, informant and accused for praying for quashing and setting aside the proceeding in GR case number 480/2015 in connection with WPS case number 73/15 under section 447, 354, 392, 201, 323 IPC pending before the Court of Chief Judicial Magistrates, UPR. Stop. The prosecution case in brief is that based on the written FIR lodged by the petitioner number 187/2015. A case being WPS ITA number 73/15 under section 447, 354, 380, 323 IPC was registered and investigated into stuff. Completion of the investigation, the investigating officer submitted charge sheet against the accused for offense, for the same offense. Which section was dropped at the time of filing of, at the time of filing of charge? There, the Lanet Chief Judicial Magistrate framed charge against the, by which order it was, the charge was framed? The Lanet Chief Judicial Magistrate taken cognizance of the case and framed charge against the accused for offense under section 201, para 3, 354, 392, and 323 IPC. No, just a minute. Yes, same, IPC. Stop, huh? How many evidence was recorded?
No evidence was recorded, Your Honor.
Okay. Then that on 15 for 2024, huh? And 15 for 2024. When is the
CJ.
when the agreement entered? Wait a minute.
Agreement is page number 46, Your Honor.
It is the Lani Council for the petitioner submits that the incident is alleged to have taken place in the year 2015. The trial of the case, sorry, however, so far, no evidence has been recorded. Stop. Huh? In the meantime, the matter has amicably been settled between the resolved between the parties by executing a settlement agreement on 17/7/2025. The settlement agreement, among other, contained that the informant and the accused are well acquainted with each other. And both used to own similar type of restaurant during the relevant stop. When semicolon, the accused has adequately compensated the informant for damages caused during the alleged incident. The semicolon, the informant has given pardon to the accused, and she has no further grievance against the accused, and does not wish to pursue with the matter any further. Stop. The Land Council for the petitioner submits that in view of the above fact and circumstances of the case, there is no possibility of conviction. Therefore, pray for setting aside of the proceeding against the accused. Ms. L. Hagelan, additional PP, public prosecutor for the state, clearly submit that in view of the amicable settlement between the parties, and also considering that, the incident was alleged to have occurred due to misunderstanding with parties, and the petitioner and the accused has adequately compensated the victim for damage caused to her in the incident. She has no objection if the prayer of the petitioners is allowed. Start. Okay, then the conclusion. Okay, we'll complete the disposal.
Deeply obliged.
Rest all.
Matter number 21.
Okay, 21.
It's a great petition filed by the informant in the alleged accused for quashing of FIR filed before the removed PS case.
Whether the record was called for?
Yes, last
Record is there?
Yes.
Yes, what is this joint petition?
Yes, sir.
What is the offense involved?
Offense, Lordship, 118 subsection 2.
What is this 118?
Previous injury.
And,
Only Lordship.
okay,
118.
so 326 IPC.
Yes, earlier.
Okay, then, what is the status of the trial? Charge framed?
No, only
It's under investigation, still under investigation.
investigation completed. However, they have not submitted the charge sheet.
Then it will be a little difficult.
No, we have come on joint.
Maybe,
Settlement.
but then you see. But it will be difficult. How do we interfere with the investigation under the such grievous injury? It will be difficult.
Lords, during this investigating period, is they have settled the matter.
Maybe, it cannot be. Certain cases, see, now where is the FIR?
FIR is that
Then in that case, you see, there will be no cases. Everybody, those who have a money will have the right to assault anybody and then just pay amount. And then you see, there will be no case. Then the poor will have to be ready to bear with all those ill treatment, assault, etc., only to be paid later on. In the case where it involves, and then where it involves or affect the society at large, it will be very difficult.
Lords, this is the case wherein
Where is the FIR?
16 page.
Page 16. He broke left hand. It's very difficult.
Lordship, this is not the case. Lordship, we have settled the matter.
After
Lordship, what
breaking hand,
happened
you
is,
can't settle the matter.
Lordship, what
It's
happened?
non-componable case.
Yes, exactly, for which we have come before this honorable court passing. Lordship, what happened is both the parties, actually the petitioner number 1 is the higher wage level. Petitioner number 2 is the owner of the building.
Doesn't have equal right to assault. The
May I
employer.
may
That
I
never-
brief the fact, because Lordship, since the record was called for, the record is with me, Lordship. But
Yes, what is there? You just tell.
what if the IO says that that there are only, there is only pushing and pulling and they fell,
But hand broken.
and medical report says it's previous,
Yes, see,
tender swelling.
that's the difference between the employee and employer.
And the other witnesses says they with they have some hot argument and pushing and pulling is there and they fell down. Same with that. So also,
Did you pay any compensation?
Lordship, both the parties, they some injury. It's not something like hand was broken. I'm not privy to the medical report. However, whether medical report comes with
What interest the medical doctor have to report?
no, I'm not privy to that. However, it's just a previous injury or it's a broken hand. That I don't know. However,
Injury
instantly we
report
have
of this
resolved the
case,
matter
injury
and-
report of this case.
However, we have instantly resolved the matter. We had together, there was nothing because even I have in the petitioner number 2 incurred some injury. So we have amicably resolved the
Is there
misunderstanding.
any record says that the
Yes, Lordship,
assaulter, he
medical,
has also received some injury?
only Lordship,
Victim.
left hand, there was tendon swelling or only Lordship.
On whom?
Here is the
The-
report.
The accused.
Injuries of tendon swelling.
When the incident took place?
It was on 28th June 2025.
Grievous.
Yes, yes.
Incident took place month of June.
Yes.
But while the police is not filing charges, see, in the previous case, interfering with the investigation very difficult. It's very difficult. It will amount to an interference with the investigation.
Also, here in the case, what happened is the incident was happened. They filed a.
No, we could understand, whatever it may be, it will come because we could understand the sentiment of the employee.
Lordship,
And then what the employer here is apparently clear only.
This is purely arises out of private nature, private in nature. Both of, now he is working with us.
Now see,
Now
now
we are harmoniously coexisting peacefully. We are living together. What happened is instantly he has
otherwise normally the laborer will not dare to file FIR against his owner or the employer unless it is a grievance. And because of that only, so that we could under such circumstances, if we interpret at this stage, it doesn't look nice. It amounts maybe like supporting the employer, the HEPs. There is a difference between HEPs and HEPs not. So now you are also not saying that you have adequately compensated because of treatment and all.
we have given the treatment.
Where have you stated?
No, I have not stated, but he has. Lordship,
See, the agreement can be entered all with threatening also in such cases. We have seen. There is a record also. After assaulting and then you obtain the agreement also under that threat, it will be difficult. We have to, because we are, this court is, we have to give justice.
Lordship, even if for an instance, if the charge sheet is submitted, or initiate the proceeding, both the parties are before this honorable court on affidavit with the settlement.
Pray for discharge if there is nothing, if that is so. But then court, even before completion of the investigation, interfering would be difficult. Let it file charge sheet, then make a prayer that proceeding would be, make a prayer. After filing of charge sheet, we will be able to ascertain whether there is a serious case or not. And then these, we especially
Lordship, in that
the
case,
Supreme Court also doesn't support
Lordship, in that
interfering with the investigation of the case.
Lord, circumstances, may I submit in some other day because I have some judgments.
Okay,
rendered
that
by
will be
the-
better. That will be better. And in the meantime, you also instruct if the charge sheet, because this is supposed to submit charge sheet within 60 days.
Yes.
So let them submit charge sheet. And then once it is submitted, charge sheet is submitted, and then your prayer, we will consider. But then interfering with the investigation of the case is, I find it little difficulty. Because there are a lot of Supreme Court cases also, not to interfere with the investigation, unless of course, there are unnecessary petty cases. So, but here in the previous case, I would not like to interfere with. You take some time, we'll fix it. And in the meantime, if you you produce the updated CD, or if the charge sheet filed, then we'll call for the record, let it registered. And then if you take, just take chance, if the fixed case for framing of charge, take chance. Let them frame charge also. But then since there is an agreement between the parties, even if you show some at least sign that you have adequately compensated and then help in treatment also, then this court, after that, we will not, of course, we'll try to rethink about it. But then I don't want to interfere with the investigation.
Lordship, in fact,
Can you come back? Can you come back and then
Okay, I'll come back. I'll come back with
next? Okay. As agreed upon by both the Land Council for the party, let this matter be listed after 4 weeks. Okay, on which the updated CD will be produced. Okay.
Lordship, may I pray that matrimony fix after 2 weeks? Any date if the charge is submitted? Then
See, if the charge is not filed, I don't want to. I said I have indicated I don't want to interfere with the investigation of the case. And it's the grievous. It's a grievous case, grievous hard case. I don't want to interfere with. It will amount to interference with the investigation. Then what they will say? The court interfere with investigation, not allowed investigation also to complete.
the matter would be different. Lordship. For
Then
after 2 weeks, any date if charge is
and then it will be better, supposing if the victim himself filed for withdrawal before the IO stating that it was because of this and I have been, for that little hurt, he has adequately compensated, treatment, help. Now I have no more grievance. Let me allow me to withdraw my FIR. That at least afford. But then I don't want to see this with the, or interfere with the investigation, this court particularly. Okay, in the case, in some case, of course, yes, after 3 weeks, okay, then make it 3 weeks. Obliged.
Item number 22 and 23.
Yes,
My lord, item number 22, this is an impleadment petition. My lord.
implement of,
Impleadment of, my lord, legal heirs of the respondent.
okay,
My lord, after the judgment, the date of judgment fixed on 13/3/11/23, the claimant respondent was died.
claimant, you are for claimant.
Yes, my lord.
The case is under trial.
No, my lord, the date was fixed for judgment on 3/11/23. Oh, sorry, my lord.
Judgment before tribunal.
Yes, my lord.
Then,
My lord, during the period of argument judgment, the claimant was died.
okay,
So on the first, there is a 2 date was fixed for judgment. First date was fixed for judgment and 23/10/2023. And the day the case was fixed for judgment. The claimant was alive. On that day, the judgment was not passed. So later on, in which days the case was fixed for judgments, we are unknown. So after we came to know that the judgment was passed on 8/8/2024.
judgment already delivered.
Yes. Then we came to know that when I communicate to the claimant sides that the judgment is passed. So
Judgment granted, any award?
award granted, my lord. Award granted. Then after the insurance challenged challenge on the judgment passed by the tribunal. So now the claimant respondent is died. So she has the 2 daughters alive at the time of accident. They was the minor. So now we want to implicate that legal heirs of the deceased claimant respondent
Where?
in the MSCT and MSC appeal as well as in the IWA.
Before the trial court?
No, my
Before the
lord,
tribunal?
this honorable court.
Here, what you have filed?
My lord, because of the in the trial court, after the judgment,
Who have filed?
after the judgment, the
Yes,
claimant
insurance-
respondent
national
was died.
insurance has filed.
Yes, my lord. Appeal is
Challenging
filed by the insurance. Appeal is filed. We are respondent.
Their ground for appeal is,
Ground for appeal is the amount is high. There is not any high. Only 6 lakhs was awarded, my lord.
you said that the claimant died prior to,
Actually, prior to the judgment, not the first date was fixed for judgment. On that day, the claimant
No.
was alive.
no, there itself, you could have filed for review to change the name of the claimant.
Yes, man, it was too late because of after the
Then
judgment.
how do you expect this court to, unless you file a condemnation?
Condemnation, my lord. Yeah, my lord. After the
See, automatically it appeared
yes, my
that because he expired prior to the judgment.
yes, my yes, my lord.
Now, can this court, because the death judgment you have not challenged. That judgment is yet to be challenged because that judgment, as per that judgment, the claimant name is still there. But even if we change here also, then that remains in the name of the the father. Unless that is changed, what is the value of changing here? Because you will be paid on the basis of the passed by the tribunal.
Yes, my lord.
Unless that is changed, you have to challenge that to change the name first. And then here, automatically your name will be implemented. But how do they implement you? Because they are still under the impression that the claimant, the father is still alive. That is why
No,
the
not
insurance
father,
did not
daughter.
impede you.
Not father, daughters.
Daughter,
Daughters.
yes,
Yes, my lord. The main fate is
you have to challenge. You have a small application only to change.
yes.
You
my
could have passed. You could have filed just because this is an error apparent,
Yes,
because he was no more
Yes.
at the time of passing.
yes,
It is automatically they would have to grant. Same judgment, but only the name will be changed.
this is my lord came to know only after getting the notice. of
Maybe
this
that is
honorable
why you should be truthful.
After make appeal notice, whenever make appeal notice was received by them, then we came to know that the.
Then immediately your first the thing should have been to go to the tribunal to change the name because you have been granted.
Yes, my lord. So whether this time is permitted by the law after the passing the judgment to implement the legal heirs of the deceased.
In the
claimant?
judgment itself, you have to review. Review for changing of the name of the legal heir,
Yes, my
name of the claimant only.
Yes.
Why can't they?
No, my lord.
What is the option left? That is the option. That was the only option
Yes,
at that moment.
yes, my lord.
But now even if I change also, even if we change here also,
Yes.
but if it will be directed to the tribunal, your father name is there, not your name. Ask for your father, automatically you have to change there. You first go there. Either you file a review petition and then challenge here. Challenge here means for implement or changing of that.
Yes, sir. Therefore, I'm filing this IA for to
No.
implement.
See, Mr. Das, you are not understanding. Even if this court implead you also,
Yes, my lord.
but then judgment is not in your favor.
Yes, my lord.
Judgment is in favor of your father only. That need to be changed. That you are not going to be implemented here there, unless you make a prayer there. We cannot change the judgment,
Yes, my lord.
isn't it?
Yes, my lord.
We cannot change the name of the party in the judgment.
Yes, ma'am. And my lord, this make appeal may be abated until we have filed a review petition and getting the order. Then after we again because
this
of
is
MSC appeal is filed by the appellant insurance company.
Mr. Das, Learned Counsel for the applicant.
Then may allow to file a review petition before the honorable.
By filing this, by this application, the no, just a minute. Mr. It is submitted that when he died,
My lord.
the claimant in make a MSCT case, where is the number of the case?
Case number MSCT case number, my lord, 9 of 15/2022.
It is submitted that the claimant, what is the name of the father?
Not father. This is the
Claimant.
claimant name is Amia Barbara.
He is no more.
She is no more. She is.
She.
She is. He is the wife of the deceased husband. Her husband was died in an RTA, road traffic accident.
Husband died in road traffic.
Yes, ma'am. Then after
And then wife filed claim
Claim
petition.
Yes.
Okay. It is submitted that the claimant in MSCT case number 15/2022. Which court, which tribunal?
My lord, District West Kamam or Bomdila. MSCT Tribunal Bomdila.
Where is the, have you annexed the judgment? See, you have not annexed the judgment also. Bomdila.
Yes, my lord.
Okay, just take it again, huh? There, huh? After hearing, that's. So who appears for the respondent or insurance company?
Nobody is present.
Nobody. That's Miss. Okay. The learned counsel for the applicant submits that Mrs. Amia Borbora
Yes, my lord.
file a claim petition under section 166 of the Motor Vehicle Act 1988 before the Motor Accident Claims Tribunal, within bracket MACT, at Bomdila, at Bomdila, Arunachal Pradesh, claiming compensation of rupees, how much?
15 lakhs, my lord.
15 lakhs on account of death of her husband, late Arun Chandra Borbora, in accident occurred on 27/7/1997. Start. Para. The learned tribunal, by an order dated, by judgment dated 8/8/2024, awarded a compensation of rupees 6,08,684 rupees, only with interest at the rate of 7.5% per annum, and directed the respondent insurance company to pay the compensation within 30 days from the date of receipt of judgment. The learned counsel, the learned counsel for the applicant submits that the claimant what was the name?
Amia Barbara.
Amia Borbora, expired on
03/11/2023.
03/11/2023. Then it should be in continuation of the earlier sentence. However, before passing the said judgment dated 8/8/2024, the claimant Amia Borbora expired on 03, you said?
03/11/2023.
03/11/2023. So the learned counsel for the applicant further submits that expired on 03/11/2023, leaving behind her Who? Two daughters.
Two daughters, my lord.
Two daughters or son?
No, daughters, my lord.
Two daughters. Namely,
Aparajita Barbara
Aparajita Barbara.
and Nandita Barbara Kolita.
Barbara and Mrs. Srimati Aparajita Barbara and Mrs. Nandita Barbara.
Within bracket Kolita.
Barbara. Huh? In the, the father son is there. In the meantime, the insurance company, the respondent insurance company has
Appellant, my lord.
filed an appeal number being the appeal before the Honorable High Court, being number as MAC appeal number 09 AP 2025, challenging the say judgment and awarded 8/8/2024, making the claimant Mrs. Amia Bora is the respondent. Who are these other three? Dorji Leta.
They are the, my lord, owner of the vehicle,
Okay, okay.
and the driver of the vehicle.
Huh. It is submitted that after death of their mother, the legal heir, so present applicant, had no knowledge about the delivery of judgment in the MSUT case number 15/2022. Therefore, it is 15/2022. By filing this application, the legal heirs of the claimant Amia Barbara seek their implement in the make appeal number 09 AP 2025. Stop. Huh? Para. However, at this stage, Mr. Judge, Planet Counsel, submits that since the judgment and award in the in the MSCT case number 15/2022 has been passed in favor of the claimant Ms. Srimati Amia Barbara, he may be allowed to he may require to make appropriate application before the learned member motor accident claim tribunal at Bombilla for improvement of the legal error in place of the.
My lord, may I say something? My lord, as the judgment is already passed, if we file there in review petition and implement their legal here, then the calculation will be something different. So there is something citations and judgment and order passed this honorable High Court. In the appeal also, in High Court also, the legal heads can be implemented. So such citations is there, Your Honor, my lord.
You file appropriate application and then give citation also, but then you see that it will not change, probably, most probably. It ought not to have changed.
My lord, if the
I
legal
mean,
heads will be implemented there, the calculation will be something different because of there is a loss of parental consent term is there. And here in this case,
Naturally, you did not inform. Why you did not inform?
then the pending MSCT appeal is also challenged here, then it will.
Now,
be completed.
immediately after that, you should have informed. Why you kept silent? You have to face for that. You have to pay for that. See, in the case, this is, you see, it must have been, they must have been aware about
Yes,
the
ma'am.
case. And then counsel who appeared there before the tribunal?
Tribunal in MSCT is also, I did appear.
See,
Yes.
if you play something,
Yes.
you have to pay for.
Yeah, my lord, my another humble comment, if the notice may be issued to the resident, if they have any objections, this court can be also implemented. And that will be the time will be saved.
Naturally, the calculation will be, of course,
Definitely.
based on the legal error.
Yes, Your Honor. Yes,
They will change.
Yes, my lord.
Why should you should be truthful? Whatever may be, you have to face the consequences
My lord,
by telling the truth.
therefore, requesting to this honorable court, maybe please at least issue the notice. If then
Your conduct,
after issuing
I
the
really,
notice,
really see, it's not appreciated.
if the main contesting party will not any raise objection, this honorable High Court.
What
can
you are
also-
talking about the objection of? There's the legal complications. You have to be truthful before the court.
It will be something, I think, contradictory. If you file a review petition and already MSC appeal against the judgment is
Why you
here
did not
pending.
inform?
So kindly see that as my mother is also that, my father is also that. By seeing as a welfare legislation, if the time is will be
You
saved,
have
if
misguided
the
them. You have
implementation is
misguided
allowed
them.
by this board also, there will be definitely time will be saved, my lord.
You want notice be issued here.
Yes, my lord. My humble request, notice may be issued to the respondents. If they will raise any objection, then we'll see, my lord.
What are you saying? You have to dictate. Forget it. Then, Mr. So and so, huh? By this application, under order 22, rule 246, read with article 26, 226 and 227 of the Constitution of India, the applicant prays for improvement of the legal error of the respondent claimant in place of the respondent number 1, Ania Borbora, in IAC number 1. What is this IAC number? 137/2025. In MSC appeal number 09/2025. Not in MSC, make appeal.
Make appeal, my lord.
Not in make appeal.
No, make appeal as well as the IA 137/25. 137 is delay condon petition filed by the appellant respondent because of there is
Who
something.
expired on 3/11/2023 after the judgment and award dated
8/8/24. 8/8/2024.
8/8/2024
Yes.
in MSC case number 15/2022. Stop. Issue notice. The applicant shall take steps upon. Delay not yet condoned.
Delay yet not condoned because of, my lord, if we are unable to submit any written objection as the
Issue notice.
yes.
Delay not yet condoned.
And
The applicant shall take steps
yes,
upon the respondent by a registered court with as well as by usual process within a week from today. This is matter after
After 4 weeks, after, my lord, there is a respondent number 2 and 3. Uh, they are the ex parte in the trial court. So as per order 14 rule 4, if they are ex parte in MACFL, they are not court.
Have you made them party?
Actually, I have made as a, because of they are mentioned in the judgment.
See, we do
Okay,
not
okay.
know, we do not know what is in your mind.
Yes.
I am warning you, don't play with the court. Don't try to play with the court. Be it tribunal, be it trial court, be it judicial magistrate first class, session court, or high court. See, it's very difficult to understand such people.
Just, okay.
Matter number 27.
You will not gain anything now.
Yes, but-
Yes.
Public
Yes, this is criminal petition is for
joint petition.
joint petition.
Yes.
You have a case. What is the section involved?
Section Lordship, 324, voluntarily causing grievous hurt with
324 and-
dangerous weapon. Only Lordship, 324.
Okay,
Between two friends in the college, Lordship.
okay.
Lordship,
Uh,
there was an argument with the girlfriend by the accused person.
Charge sheet filed,
Charge sheet filed.
trial begun,
Lordship.
charge framed,
Not yet, Lordship.
not yet.
It was fixed on 7/6/2023 for appearance of the accused person.
7/6
7/6.
appeared? No,
No,
not appeared.
on first accused was appeared, Lordship, but next date was fixed for CC, but yet not framed, Lordship.
So, how many accused?
Accused, only one accused person, Lordship.
Okay, informant and,
Informant,
let us
Lordship,
see the party's name.
yes, Lordship. Lordship here,
One is
one is the complainant
informant.
and he informant, and he was the elder brother of the victim, but victim is not implemented in the main petition.
No,
So,
victim is to be implemented.
yeah, Lordship, there was a subsequent direction
Subsequently,
from
okay.
here.
This is victim.
Yes, Lordship, yes. He was.
3 is victim
Yes, Lordship, 3 is
and 2 is the
accused
accused.
person. Lordship.
And whether in the agreement, whether the victim is also party,
Yes, Lordship, Lordship.
where do we see? Find that?
Page number 24, Lordship. Is the settlement whereby heavy fine was also imposed to the accused.
24.
Yes. 26 is the type copy, Lordship.
Hmm?
Yes.
What is this?
And Lordship,
Where is the name of the victim?
page number 25, original copy, Lordship, and down, Lordship. Total is ending, Lordship. Accused person, Ikaram complainant, Ibam Renya, victim. Page 25 is the original agreement, the ending, Lordship.
Where is the original?
Lordship.
Where is the original of this agreement?
Agreement, original is with me, Lordship.
You have to submit the original.
Lordship.
So original you have kept it for Supreme Court.
No, Lordship.
Then
Generally, Lordship, by incorporating certified true copy, we usually annex the photocopy, Lordship.
see, this is handwritten. That is why I'm asking.
Yes, Lord.
And in this type in some other pages.
Yes, Lord.
Had it been in the stamp paper,
Yes.
certified, then of course would have been, see, there no question of doubting. But then this is a handwritten, and there is no serial number of the victim also.
True, Lordship.
This doesn't look actually. Is subsequent insertion or what? Something. What is this in? This is in Adi.
Kalo language.
Oh, no. How do we understand?
That's a translate copy is at 26 and 27 in my petition, Lord.
Yes, it was subsequently added. Name. Afterwards. Can we get it listed? Because today, in any case, I have some other case also to be dictated, will not be able to. So we'll get it listed day after tomorrow, we'll dispose of, okay? Due to paucity of time, the matter could not be taken up. List this matter on Thursday, okay? Thursday again, so we'll dispose of, okay? We'll consider, but we'll dispose of. You have, a record is there, keep it, okay?
No, no. Here was called, teacher was called for this.
This is TCR,
Yes.
okay. We'll keep it, keep the TCR with you.
No, normally
It-
the
okay,
teacher.
it was called,
by
it
the
was called by the court.
Yes.
Okay. It's fine then. We'll dispose of that.
Quickly, I would like.